Yes.
My lords, there are two, I'm afraid, administrative issues to bother you with first before I make my substantive submissions. The first relates to the application that was made by the respondent on the 16th of December to, sorry, apologies, it was the 18th of December, to rely on a unagreed bundle of documents. I didn't want to interrupt my learned friend in her flow, and obviously she doesn't agree that those documents are relevant. But I was hoping that your lordships would have that bundle.
I've certainly got the bundle.
Thank you very much, my lord.
Well, I haven't seen this coming. We haven't looked at it so far. It's very difficult to say that somebody should not be allowed to refer, for example, to transcript of a witness before the judge, or written submissions made to the judge, or an expert report referred to by the judge. Ms. Foster?
Well, I entirely agree.
Good.
But the appellant's position is that that documentation isn't relevant, so we
Well,
were going to trouble the court.
all right, but
It is a bundle.
it may be that Miss Walker refers to it and we think it's not worth the time of day or the price of fish, but
I don't seek to stop her.
you're not seeking to exclude it as a matter of...
Not at all, no.
Good.
Thank you, I'm
Right.
grateful, my lord. It spares me from saying that one of my learned friend's submissions was that Mr. Vince was the only expert who'd assisted the judge who had any experience in applying restraints or working in similar settings. And in those circumstances, it seemed unusual that there was resistance to both his report and transcript going before your lordships. But I will proceed, and there are some references which have been made, you will have seen from the skeleton argument, and I'm not going to go into them in too much detail to Mr. Vince's report. And the proposition, or the reason that the closing submissions were considered relevant was simply to highlight, in their absence, some of the points that are now being run that were not run at first instance. And I will sweep those up in the course of my submissions anyway. I don't intend to take you to the absence of those points in the closing submissions, obviously, but it was simply, in particular, to counter any suggestion from my learned friend that that was the way the case was put at first instance.
Yes.
My lords, I have three general points to make in response to the opening comments that were made by my learned friend, before I move on to looking specifically to grounds 1, 2 and 3. The first point is to address very briefly the time that my learned friend spent in her submissions referring to the negligence claim. And given that this isn't a subject of the appeal, there's no cross appeal on the negligence finding, I obviously don't intend to trouble you with that, save to note the important point, which is that my learned friend made the submission twice in the course of her opening, that the negligence aspect of the claim was the dominant, or was the majority of the entire hearing. I should add, my lords, I'm not sure to what end that submission is made, but it's simply factually incorrect. So I wanted to correct that matter. My learned friend said in her opening comments that the hearings and the 9 days of hearings were focused entirely on extensive allegations of negligence. And the reference for that, and the reference for why I say that's incorrect, is in the judgment on quantum and costs, which you'll find in the core bundle at page 113 and paragraph 40. And the judge clearly records that that was not the case. It was not the case that the negligence claims, as opposed to the allegations relating to battery and false imprisonment, was the entire focus of the trial. As I said, it's not clear to the respondent what the appellant gains from that submission in any event, but it is one that in the respondent's submission needs to be corrected. The second point, my lords, is to address the submissions that were made around the impact of the claimant's father taking on parental responsibility for him in 2009, and the what's said to be the impact on his behavioural presentation from the claimant's father's concern that the school was not meeting the claimant's needs relating to his ASD. And again, very short points, but my lord, I wanted to cover them off. First of all, although that was the argument made by the appellant at trial, and although it was pressed extensively, not least in at least one day of cross-examination of the claimant's father, it is not a finding that was made by the judge. So my learned friend is arguing again a point that simply was not found to have merit. The second point I'd make, the second sub-point, as it were, is that the way it's being put, or the way it was put, was somehow to suggest that the concerns that were raised about the appropriateness of the setting were outlandish, that the claimant's father was acting somehow irresponsibly. And my learned friend took you to the Looked After Child Review document from May 2009. And if I could just trouble you to turn it back, and I'm not going to spend long on it, but you will see that at the supplemental bundle, page 73. It starts, in fact, at page 71, but the substance of the report is at page 73. Now, my learned friend took you to the second, the paragraph from the bottom. The claimant's father had raised concerns that the claimant has ASD and needs to be in a school that specifically provides for this. I'm sorry, my lords, I realise I have read out a name which is anonymised.
Well, I don't think there's anyone in court who
It is
isn't
being live
directly
streamed.
concerned with the court. If it's live streamed, can I remind anybody watching on live stream that the anonymity of the claimant, now respondent to the appeal, and his family is protected by a court order, and even if a name is mentioned in court, that doesn't detract from the anonymity order.
Yes, my
Yes.
apologies, my lord.
Sorry.
I have tried to correct all the references in my notes.
Yes.
And some discussion took place that both parents would like the claimant to attend an ASD specific school. Now, my learned friend didn't take you to that second bit, so she didn't take you to the sentence that refers to both parents' wishes. But more importantly, my lords, she didn't take you to the references which you see at the top of page 74, over the page, which says that a report by CAMS was referred to, where it stated that the claimant...
Who are CAMS?
It's the Child and Adolescent Mental Health Services, my lord.
Thank you.
A report by CAMS was referred to, where it stated that the claimant does have an autistic spectrum disorder but is high functioning. It also indicates that the claimant has behavioural and emotional issues. They, I think from which it must have been CAMS, did suggest that a more behavioural approach would perhaps be more beneficial than a psychodynamic approach, as this is not particularly appropriate. And the psychodynamic approach is the one that was being adopted at the school. There is also references, if you turn on to page 77, which again, my learned friend didn't take you to, the top of page 77, the first substantive paragraph says that Darryl Jones, who is the educational psychologist from Camden, which is recorded earlier in the report, was asking for some more information about the speech and language therapist. This will hopefully be passed on prior to the meeting later on in the week. The issue seems to be about what provision the school has to address the claimant's ASD. And for completeness, my lord, the report from Mr. Jones, who is the educational psychologist, is in the supplemental bundle, starting at page 35. And the reference to the concerns about the interventions that are in place. And when I say concerns, I mean concerns about their suitability for the claimant. You will see at page 41. I'm simply making these points, my lord, not in any way to re-argue the negligence claim, but to identify that any suggestion or any inference that the claimant's father was acting in a way that was outlandish, in being concerned that ASD strategies were not suitable or were not being employed, any suggestion that he was somehow wrongly focusing on some aspect of his child's presentation, and that this was not supported by expert evidence, is in my submission unsustainable. But in any event, as I said, in respect of the duration of the negligence point that was made by my learned friend, it's not clear how that assists the appellant in any event. And the third and final point in opening these submissions, my lords, is the reference to the impact on the wider residential school community, sorry, my lords, or the special schools, indeed. They may not be residential. The respondent's response to that is to say, firstly, the case clearly turns on its own facts. The 3 face-down restraints were carried out by one carer, Miss Pusey. 3 face-down restraints which were found to be batteries. Secondly, in respect of the false imprisonment aspect and the use of the towel method, no evidence was produced at the time of the trial, and indeed nothing has been suggested since, that this is an approved method, and therefore that any finding that it can be unlawful, in the circumstances it was found to be unlawful by the judge, rather than its use in total, will have a significant impact on the wider school community. That's the first point about the use of the towel method. But in any event, both the findings in respect of the use of the towel method and in respect of the face-down restraints only emphasise what should be obvious to everyone in a school setting, that the use of these restraints and restrictive physical practices, by which both the respondent and the judge included the use of the towel method, and I'll come on to that in response to his lordship's concerns about the judgment in that respect, the use of them has to be carefully implemented, it has to be lawful, it has to be by reference to careful consideration through multidisciplinary decision-making, and decision-making that involves the parents. So all it does is re-emphasise that you should not be adopting practices within a residential special school that could give rise to battery or false imprisonment. It doesn't undermine those special schools at all, so long as they are actually adopting the correct approach to putting in place those strategies and methods.
Now, would you like to deal with battery first or false imprisonment first?
Yes, my lord, I was intending to deal with battery first, and given your lordship's indication that there's no necessity to pick over, as it were, the wording in the respective authorities, I don't intend to take your lordships to them, but of course I can if that would assist. They are in the bundles, and I have the relevant references.
Well, do you accept that the relevant question is whether the conduct in question was reasonable?
Yes, my lord. The structure of the submissions before I was sure how my learned friend was going to approach it was to look at the 2 aspects that I'd understood she was concerned that the judge had somehow missed from the test. And one was intention, and the other was this concept of hostility. And the respondent was going to say, very similar to your lordship, that the concept of hostility has faded away in any event. So the question then is, what is reasonable in the circumstances? And that seems to be the best way to arrive at it. And in a way, the respondent would say, puts the case back in looking at the acceptable standards of conduct, which is back at what Lord Gough, when he was then Lord Justice Gough, had said in the Collins case. So yes, absolutely, that is agreed.
Okay.
And I assume from my learned friend submissions that she's no longer running a submission which I understood to be hinted at, that there was something accidental about the use of the face down restraints. And I'd only taken that, or Respondent had only taken that, my lords, from the use of the phrase came to be in a particular position. I have not taken it, my lords, that my learned friend is now saying there was anything accidental. And my opening submission on the point was going to be that the judge didn't have to address the question of whether or not this was intentional, in which case a battery claim would be possible, or accidental, in which case negligence, because it was never suggested that this was an accident. And the closest that the appellant ever got to that position was in the submissions on quantum and costs, which were after the event, in terms of the liability findings. Dealing then with and I've dealt then with the first part, which is the intention. And unless your lordships consider I need to address you further on that, I was simply going to leave it as clear between everyone that the physical restraint was intentional and the use of the face down restraint was intentional. Looking then at the question of reasonableness, and looking at how the judge has analysed this question, the respondent certainly disagrees, and I'll say this in respect of both the ground 1 dealing with battery and ground 2 dealing with false imprisonment, with a suggestion made by my learned friend at the close of her submissions that it is somehow difficult, or is difficult, for the respondent to construct meaning from the judgment. In my submission, a fair reading of the judgment makes it abundantly clear the judge has looked first of all at what we might call the common law test of battery, and then has looked at the legislative provision, section 93 of the Education Inspections Act. But the respondent accepts that for the present purposes, there is no distinction between the tests that the judge was going to apply under both of those. Firstly, the judge analysed looking at the common law position, and again, respondent accepts there's clearly an overlap, but I wanted to deal first with how she dealt with the common law position first. She deals with this in the first judgment on liability, at paragraphs 107 to 114. Sorry, my lords, it's starts at page 92 of the core bundle.
Yes.
Now, my learned friend has repeatedly, both in her written and oral submissions, suggested that the judge simply looked at the policy and said what was appropriate under the policy. If it wasn't appropriate, if it wasn't authorised, if it wasn't legitimate under the policy, then it couldn't possibly have been reasonable and therefore must have been a battery. And in my submission, that's clearly a misreading of the judgment. My learned friend also suggested that in these paragraphs disclose no findings. And the respondent respectfully disagrees. The first finding that underpins the decision on the common law sense of battery is exactly that the prohibition on the use of face down restraint. And we find that at paragraph 114. At page 94. So the policy does not permit the restraint of the child face down. And that finding, and in fact all three of the findings which I'm going to refer to now, are not challenged by the appellant.
I'm talking about the findings that inform paragraph 119.
Exactly.
On reason.
Well, they are, the way that the judge has structured it was, and I believe your lordship referred to this, was to deal first with what might be called the lawfulness of the battery in a common law sense, but then to go on and specifically look at the factors that are relevant under the legislation. And of course, there is that clear overlap between them. So
not only overlap, I
it
think
is
you
the
say
same.
there's no difference.
There is no difference between them, exactly, my lord.
What the judge does do at paragraph 114 is reach her conclusions that the policy doesn't face down restraint, and then says she's only going to address reasonableness as an alternative in case she's wrong about the effect of the policy. So she seems to treat the effect of the policy as sufficient in itself, and then say, if she's wrong about the effect of the policy, I need to consider reasonableness, and then include under her reasons the effect of the policy.
Yes, my lord.
Is that a fair
Well,
reading of the structure of her judgment?
the respondent's position is the structure of her judgment is that she doesn't just deal with the effect of the policy, because she says that the policy does not permit the restraint of a child face down, and for the reasons set out above, the battery claim is made out. So it is, and the reasons set out above include three other findings, which are not just about what the policy says about the restraint.
I see.
So they also include at paragraph 112 that the policy doesn't qualify the prohibition in any of the ways the witnesses tried to suggest would make a face-down restraint permissible. So not only does the policy prohibit a face-down restraint, but the argument that was made by the witnesses, which is the two witnesses who dealt with this issue only in oral evidence, but not in their witness statements. There is no qualification to say that if you are unable to manage using the training that you are experienced in, you can dynamically risk assess. So the policy does not permit that. And the third, which is the factor that she deals with at 109, is around the training of the staff. So the staff do not have training in the use of face-down restraints. Now, my learned friend attempted to elide those when she took you to the policy, and she said the policy prohibits face-down restraint because that's what the training says. When the respondent submission, it's a slightly separate point. There is no training on it, and it is prohibited. They coexist clearly, but it is a separate point. So the judge was not just looking at what the policy said. She was also looking at what the staff were trained to do, which in my submission is an important factor. And it was a factor that was accepted as important by the appellant's own care and education management expert, Mr. Vince.
But I still think, speaking for myself, you're in difficulties in defending paragraph 114. Paragraph 114 seems to me to say the policy does not permit the restraint of a child face down. That's it. Therefore, the claimant wins. And for the reasons set out above, only goes to the conclusion that the policy does not permit the restraint of a child. One, staff members were required to keep accurate records. Well, that doesn't detract from the dogmatic conclusion. Two, the policy does not qualify the prohibition in any of the ways the witness says. And thirdly, the guidance makes an important distinction between planned and emergency or unplanned use of force. You're on stronger ground, perhaps, in 115 to 119, but can 114 really be right? If 114 is right, then the rest of the judgment on battery doesn't matter.
Well, my lords, the respondent's position is that can be right if you read where she has set out, the judge has set out the factors. At paragraph 110, what she's explaining is the difficulties with the lay witnesses are threefold. So I don't wish to disagree, my lord, but the factors that she set out at first, second and third specifically address the evidence of the lay witnesses. And I will come on to those, my lord, to the extent that they are relevant to a factor that was raised by the defendant's witnesses about planned and unplanned use of force. My learned friend says that was generated by the claimant. When I come on to look at section 93, I'll explain how that's not the case. What the respondent says is that it wasn't just the policy that she was looking at, because she talks about for the reasons set out above, and those reasons include, as I've indicated, paragraph 109, what the carers were trained to do. So what they are able to do safely. And that's the important point about paragraph 109. And 109 has to be read in conjunction, of course, with paragraph 108. And your lordships asked my learned friend where this concept of the safety around the use of face-down restraints came from. And at paragraph 108, we can see that it came from the evidence that was given by Dr. Rippon. It also came, my lords, and when I take you to the guidance, I'll pause and look at the 2002 guidance. There's also a section in the 2002 guidance which refers to the potential risks that arise from particular positions. So the respondent's position is that it's not just what does the policy say, it's what does the policy say and what are the staff trained to do. Because if they're not trained to do something, it will inherently give rise to a risk, which is what she has identified at paragraph 108 and 109.
But she brings that back in at 115. I mean, I wonder whether a fair way to think this is that she's saying that the policy doesn't permit the restraint of a child face down in any circumstances. If that's what it means, then that's enough for it to be a battery. And then what she's then going on to consider is if she's wrong about that. In other words, if the policy does admit it in some circumstances where it is reasonable, then I have to address the reasonableness requirement. Is that the right way to look at it?
My lord, the respondent understood that she was looking at it in two separate ways, albeit that there are the factors that coexist under both. And it's certainly right that at 115 and the paragraphs that follow are in the respondent's submission a complete answer to the appellant's concerns. Even if 114, but the judge says this herself, is even if she was wrong about the effect of the policy and the effect of the lack of training, which goes hand in hand with the policy according to the appellant, then she goes on to consider whether or not the use of force is reasonable.
But don't you accepted the issue is reasonableness? That has to be context specific. So it has to be assessed in the context of the actual situation as demonstrated by the evidence. And 114 is as a matter of policy. There's no analysis of, was this a crisis? Did I have no other option? Was this the only, did I take this step in order to protect myself, the child, others from harm? Now, if you put it that way, surely it's difficult to rule out something just because the policy says it shouldn't be used. You have to look at the situation, the dynamic situation. And the judge hasn't done any of that prior to 114.
My lord, the reasonableness of the restraint, the reasonableness of the physical contact will, sorry, I'll take a step back and And Respondent considers it's important to emphasise that the purpose of these restraints is to respond to behavioural difficulties. Now, that may seem an obvious point, but at what point does a behavioural difficulty become a crisis? And the policy is there, and the training is there to respond to behavioural difficulties, to respond to behaviour which is outside of the norm that you might expect from other young people who don't demonstrate dysregulated behaviour. And the structure is there to provide for restraint to be delivered safely in those circumstances. And that structure is provided in the training, and it is made clear in the policy.
I understand that, but if you've done all that and it hasn't worked, what do you do?
Well, my lord, then the question is there evidence that the individual had done all of that?
Well, that's why the reason I raised that is because you're defending 114, up to which the only point I'm asking for your help on is the judge has not analysed at all the elements of the situation that led to what happening.
My lord, at that point, she has.
All she said is policy, and as you said, the 3 points, records, the policy doesn't qualify, and planned and unplanned. She doesn't engage with the situations which were occurring, as set out in the records.
My lord, I have to accept that in the analysis she has not engaged with it, but if you read the earlier section of the judgment, she has clearly set out what has happened, which is from page 91 onwards. So she has clearly set out what the incidences were and where the face-down restraint occurred in the course of those instances. And I don't wish to jump across 2 different judgments, but this issue that was raised by my learned friend in the course of this appeal, which is that the restraints were part of what was otherwise agreed to be a legitimate restraint, is a submission that was only raised after the liability judgment. It's a position that was only adopted after the liability judgment, and I will be taking lordships to it, but that was expressly rejected by the judge in the second judgment. He had considered what the mechanisms were for the restraint. My lord, I can't. Sorry, my lord.
Is the policy the right place to start? If for the purposes of battery, the question is whether you look at it at a common law or under the statute, was the use of the force in question reasonable in all the circumstances? If the position is yes, it was because of the particular circumstances, let us assume for a moment that there is a situation, whether it's in this case or not, in which there is absolutely nothing else you can do to keep everybody safe but a face-down restraint. Then it may very well be said, well, the sensible thing, if that is the case, is to have a policy which expressly recognises that that may have to occur in extremis and involves training the staff in face-down restraint in order to make that as safe as possible. But having a policy that doesn't say that might give rise to an argument in negligence, but has nothing to do with the tort of battery, does it?
My lord, I take the point. The question of what the right starting point is, it was not suggested by the defendant. It wasn't just by the defendant that it was inappropriate to look at what the policy says first. So that wasn't suggested at first instance. And indeed, that was driven by evidence from Mr. Vince, who was the defendant's own expert, that the starting point for looking at whether or not standards have been met is what it says in the policy, and has the policy been followed. whether or not the policy permits something in my submission is relevant to the question of whether or not it is authorised. And my learned friend has used the word legitimate. So where is it legitimised? The restraints are legitimised because they are identified, they are detailed, and they are supposed to be set out in a...
If there were no policy at all, it would be very unsatisfactory, but it wouldn't help answer the question whether on a particular occasion the use of force in question was reasonable or unreasonable, would it?
Save that where staff are prohibited from imposing a particular restraint because of the inherent dangers of doing so without being properly trained, which appeared to have been an accepted premise for why they shouldn't be doing it. It is an indication, at the very least, that what has happened in the course of the restraint is outside of what would be expected to be reasonable.
Well, put it another way, that may be something wrong with the policy, but not be something wrong with what happened on the particular occasion.
Yes.
In the circumstances in which it arose. And at some stage, you'll address us, as far as I'm concerned, I'd like to be addressed, on whether the judge should have expressly asked and answered the question, what else should have happened on each occasion?
Yes.
What should Miss Pusey have done that she didn't do?
Well, in initial answer to that question, my lord, the respondent doesn't accept the proposition that was made by the appellant, that in order to show that something is outside the bounds of reasonableness, the judge would need to have identified what should have been done, because it's evident that what the judge has found is that the face-down restraint was not reasonable.
I understand that, and I certainly accept in the abstract you can describe something as unreasonable without having to define where the boundary line is as to what is reasonable. But in the particular context we're talking about, in analysing whether on a particular occasion what Miss Pusey did was unreasonable, would it not be necessary to ask the question, well, what else could she reasonably have done? Because unless you can identify some alternative course which was reasonably available, it seems to me rather harsh to judge it to be unreasonable.
Well, what the judge identified in the second judgment, and this was dealing with this point that was raised around the restraints being otherwise legitimate, was that there were no other restraints that were used, and there were this was in the context of the judge having heard evidence about the importance of grading restraints, and it's unfortunate you don't have the actual training, but that the PROACT method is one that goes through graded steps of restraint. So it is a case that if one form of restraint, which is a lighter touch restraint, is not effective, then you move on to another form of restraint. And the judge, as is evident from paragraph 14 of her judgment in the judgment on quantum and costs, she was not satisfied that from the record she had seen that other restraints were attempted. The RAP is one form of restraint, but it is not there are other forms of restraint, are also graded restraint that could have been imposed or could have been put in place before getting to a restraint that was a restraint that Miss Pusey wasn't trained in, and a restraint that was inherently dangerous.
Where does the judge deal with those?
So it's at paragraph 14, my lord, of the second judgment. And it starts at page CB 106. as I've indicated, if you read from the bottom of page 106, this was in response to the submission that had been made by the defendant and is reiterated as part of this appeal, that the batteries were part of what was otherwise a lawful restraint. And it's here in this the penultimate sentence, the records do not indicate that the face-down restraints were accidental. On each occasion, FXS was held in a wrap in a face-down position. And then goes on to say, on the 29th of June 2009, Ms. Pusey, this is the top of page 107, held FXX in a face-down position for approximately 10 minutes. There's no record of a prior physical restraint. And on 15th of September 2009, there is no indication from the record that the wrap that had been applied was ineffective, nor is there any recorded justification for using an alternative lawful restraint.
I wonder whether either of those are consistent with the notes. And in relation to the 29th of June, which you got at page 95, records that she did hold him in the back, but that was not effective to protect her.
That's the 16th of June record. Apologies,
I'm so sorry.
cut across it. Yes, that's at page 95. The second instance is at page 96.
Quite right, my mistake. I'm sorry. I'm not
And it goes straight to protected
protected
herself
by holding
the claimant in a wrap,
Quite right.
face down on his bed. And then the third instance,
But the third instance does indicate the use of an ineffective wrap first, doesn't it?
well, my lord, what the claimant would say was the interpretation of that record of the incident of the 15th of September is that in midway through page 97, so Prissy put the claimant in a wrap and then pushed him onto the ground. So it's not, the wrap was ineffective, so she tried something else. The wrap then goes to the ground. So it's a wrap combined with a face down. It's a face down wrap, which is not, I hesitate to say it's not permitted because I don't want to stray back into the territory of saying what isn't
It's
permitted.
governed by the words to protect herself.
Yes. The respondent's submission in response to all of these was that there's no suggestion that these face down restraints were being done for malevolent, I'll go back into hostile. There's no suggestion that she was doing these wraps for her own purposes in some way.
No.
The whole point of the physical restraints is protective.
Yeah, but I still don't see that the judge ever answered the question. Well, what else was Ms. Pusey supposed to do? Indeed, if we look at 117, which we haven't focused on so far, she almost comes close to saying that's an irrelevant question. It was suggested it was reasonable for Ms. Pusey to restrain him in the way she did because she was responding to an emergency situation. She was required to undertake a dynamic risk assessment. I think that's a fancy way of saying they make a decision on the spur of the moment as things were happening. As stated above, there was no such exception within the policy. So, saying the policy doesn't make any exception for emergencies. In any event, FSX's behaviours were well known, and then she goes on to lack of planning. Now, that seems to me anyway to be an arguable factor in the claim for negligence, but why does it make any difference to battery?
That the behaviours were well known.
Yeah.
The starting point is that the respondent would say that is something that the appellant had introduced by way of an explanation for why these restraints were being used and why a face down restraint was what Ms. Pusey had to go to. It was the appellant's case that it was because his behaviour was in some way unexpected, that a planned intervention could not be used. So the reason that this, in the respondent submission, shores up the battery claim is that when you are assessing what is reasonable in the circumstances, the respondent submission is that the judge is rightly looking at what mechanisms are available, and the mechanisms that are available are restraints and physical interventions, or indeed de-escalation, leaving the room altogether, that are available within the training. And what was being said to the judge was that Ms. Pusey did not go to any of those restraints because it was an unplanned situation. So any of the strategies, any of the physical restraint strategies that are there to deal with his behaviour couldn't be used in those circumstances because it was a crisis. So it is relevant to think, and the defendant's case was that it was relevant to consider what behaviour he was presenting with at the time, which is why the judge then looked at the fact that his behaviour wasn't unexpected. And she did that particularly in response to Mr. Vince's evidence, because he had said his behaviour was unexpected, and we see this at the remainder of paragraph 117, because he was setting off a fire alarm. So he was behaving in a way that was not expected. And therefore, one of the strategies that wasn't the trained physical restraint strategies, it was appropriate to use.
Can you remind me how many incidents of physical restraint were relied on or alleged? I think, was it 117?
No, my lord, it wasn't all 117. By the time it got to trial, there were, and by which point the claimant's experts had reviewed the reasonableness and proportionality. In addition to these 3 instances of restraint, there were 4 others that were...
No, how many incidents of restraint were there? Not that were...
Oh, I'm sorry.
During the course of the child's presence in the school.
I think, my lord, not those that were averred to be unlawful. But
Exactly.
How many restraints?
The figure that was suggested was 117.
Right.
My learned friend provided a figure to the court of 550 behavioural incidents. And as you might have seen from the respondent's skeleton argument, that figure was not accepted because it was drawn from Mr. Vince's analysis, and it wasn't clear from his analysis what he'd meant by behavioural incidents, and indeed he was asked.
So there were 117 occasions on which physical restraint had been used. Is that right?
Yes, my lord, yes.
And so far as the face down restraint is concerned, how many of those were there?
There were three instances.
Only 3.
And all by one member of staff.
And how many other incidents of physical restraint was Miss Pusey involved in?
I don't know, my lord, and that point was never, the point that's been made today by my learned friend, which was that Miss Pusey was highly experienced and had experience in managing the claimant in a way that was in accordance with the policy. That was not evidence before the court. There was no witness statement from Miss Pusey, and evidently, as you've seen, Miss Pusey did not attend to give evidence.
And it wasn't referred to by any of the other witnesses?
No. And the experience of Miss Pusey in managing the claimant's needs was not referred to in the witness statement. And there is, of course, the hole in the evidence of all of the witness statements in terms of the evidence of all of the appellant's witnesses in terms of their witness statements, that the matter or the fact of face-down restraint is not referred to at all.
I understand that if one's looking at is it exceptional or unusual for this to be used, it would seem that the answer is yes, because there are 117 incidents of physical restraint, and this particular feature only occurs on 3 occasions.
Yes, my lord.
So
and
that is another part of the context of looking at what's happened.
My lord, yes, save that it is 3 restraints that were all carried out by one person. If I would...
That might or might not be statistically interesting. If Ms. Pusey was also involved in a considerable number of the other incidents, that would not help you, would it?
One,
If these were the only incidents she was involved in, then that might be something.
yes, say that there would,
The fact that it happens to be her on these 3 occasions, it doesn't help us very much without the bigger picture, is all I'm putting to you.
yes, my lord, the only bit that does help the respondent, the bit that does help the respondent is the fact that this day's evidence, albeit not in her witness evidence, only in under cross-examination, was that she had spoken to Miss Pusey after the first instance, and then it happened again twice more. So the relevance of that is that even after it had been identified that there was a difficulty with Miss Pusey safely restraining the claimant and doing so in a way that didn't involve a face-down restraint.
So did Miss Day identify that there had been a problem with it?
She didn't identify that there'd been a problem with it in her witness
What's the
evidence, no,
significance that it happened twice again?
because she has said that she had spoken to her about it and it had happened on 2 further occasions. So I think the point being that unless
She'd spoken to her, tell me if I've got the evidence wrong, but as I understand it, she said I'd spoken to her about it and I was quite satisfied that on that occasion there was nothing of any concern in what she'd done. If she were right about that, then what was the significance of it happening on 2 further occasions?
well, because if she was right about that, then Miss Pusey, I think the suggestion was that she was given some further advice or some further training, although that wasn't recorded in any of the documents, which would indicate that something needed to be addressed in the fact that she was conducting the face-down restraints. But my lord, it was difficult because Miss Day didn't refer to this in her witness evidence, and she only referred to it, it seemed to be as something that had come to light and wasn't recorded in any of the records that these conversations had taken place at all. I accept the point that if she doesn't think something's wrong with it, does it matter that it happens twice more? And the respondent says, yes, it does, because there's a reason that the carers are trained in a particular way, and there is a reason that they apply restraint in a particular way.
I quite understand you say it shouldn't have happened, and it shouldn't have happened once, it certainly shouldn't have happened 3 times. But I'm just wondering whether the conversation with Miss Day really takes your case any further.
No, I take the point.
Can I'm sorry to... You're gone.
Is it relevant that we learn from paragraph 108 of the judgment that PROACT was replaced in 2010-11 by Team Teach, which allowed face-down restraint and provided training in face-down restraint?
My lord, the respondent would say it's not relevant. The reason being that there was no information or no evidence about the circumstances in which that face-down restraint could be deployed. So there's no, if it had been first we say it's not relevant because that wasn't the training that was in place at the time. And what staff are trained safely to do, the respondent says, and the judge agreed, is one of the circumstances that's relevant, or one of the relevant factors. So they weren't trained in it at the time. So whether or not a year later or 2 years later they become trained in a particular method doesn't make the fact that there is a restraint with no training acceptable. The other point is the point that I started making, my lord, which is that it's without any information about the circumstances in which that face-down restraint can be used, i.e. can a team teach face-down restraint only be used if there are 2 people there? One to check that the person is safe and the other person to do the restraint, for example. My lord, we don't have the information. I'm simply anticipating that there might be circumstances in which you could say, well, that would not even apply to this situation in any event, because evidently Ms. Pusey was restraining the claimant alone. So for those reasons, those 2 reasons, my lord, the respondent says that it's not relevant.
So can I just want to take you back to the point we were on earlier about whether there was a reasonable alternative identified, and we got on to paragraph 14 of the second judgment, and we're looking at the record of the third incident on in September at page 97, which is the one that talks about putting him in a wrap and then pushing him onto the ground face down to protect herself. I think you were saying that what the judge was saying in paragraph 14 of her second judgment was a fair way of interpreting the document, but because it doesn't expressly say that the wrap was ineffective, it's reasonable to interpret it as an example of a case in which it wasn't a gradated response. Is that really a fair way of reading these documents? Because it hasn't said expressly the wrap was unsuccessful and then pushed him to the ground, it is to be assumed that that wasn't the case. And that does strike me as the judge was faced with a difficult job. Everybody in this case was faced with a difficult job in interpreting the documents, but that does strike me as a rather unfair way of reading a document if it's going to form the basis for saying that someone has committed a tort.
The point of the records, and my learned friend indicated this earlier, is to allow for some monitoring and to allow for a record of the restraints that are used. And if that is right, and it is clear that a restraint has not been effective, then in order to ensure that the records are kept and that they are of useful purpose, you record whether or not, that you record the restraints that have been used and record whether or not you've graded through them. And that's, the purpose of that is a monitoring purpose, and it's also a protective purpose to ensure that physical restraint is not used that should not otherwise be used. In circumstances in which the defendant elected not to produce any evidence from Ms. Pusey and elected not to produce a witness statement, the claimant's position was there is a physical contact here, evidently intentional physical contact, and it is, on the face of it, unreasonable if it was then for the defendant to produce evidence that there was a lawful justification for it. If all that the judge can do is look at the records, then the unfairness, if there is such, is the defendant does not address that through the adducing of any evidence about self-defence or the evidence or alternatives that were available.
Well, let's unpick 2 points there. One is that Ms. Pusey wasn't called to give evidence to explain this, and I think the judge said that's entirely understandable, and given the circumstances, no adverse inferences can be drawn from that. The second is how you read the document, but one needs to be a little bit careful about what you say is clear on the face of it. This says he's put in a wrap and then pushed onto the ground face down. Now, one might say, given the circumstances, that could only have happened if the wrap had not been effective, otherwise she wouldn't have had to go to a second stage. Would that be a reasonable interpretation of the document?
It's not, the respondent would say it's not a reasonable interpretation of the document when one reads, in fact, particularly if you read the two instances together, that what Ms. Pusey is doing, in fact, is adapting a technique. It's not that they are ineffective, it's that she is adapting a wrap which should never be a face down restraint, and she is making it into a face down restraint. If you read the two together, that is what the respondent says is the reasonable inference from them. Because she did the same thing on the 29th of June. She held the claimant in a wrap face down on his bed. So if you read them together and you read the accounts together, she is a reasonable interpretation of it, and one that was open to the judge. And in my submission, that's the important point to come back to, is was it open to the judge? Is that she is using a technique that she's not trained to do, with an inherent risk attached to it. The only other point, my lords, is that, and this circles back to the question about whether or not the claimant would, at first instance, have had to show that there were alternatives that could have been put in place. In my submission, that's not a proposition that one can safely draw from the authorities, that there is an alternative that could have been carried out such that it wasn't a battery. The question is,
was it unreasonable, which involves, first of all, identifying what happened in the circumstances, and then addressing the question of reasonableness to that. And I think the claimant bears the burden of proof on both of those, but of course there's a limit to the evidence that's available, and everybody has to do their best with the evidence that's available. But it is, insofar as the question of reasonableness arises, it is for the claimant to show that what happened was unreasonable, and in that context, what alternative was available is surely a relevant question to ask.
and the alternatives that were available would have been, and it was evident from the rest of the evidence that the judge had heard, would have been another form of intervention on which that carer was trained, and there's no indication that that was tried.
Do we know what they were?
Yes, my lord. Well, again, it's a difficulty because you don't have the
We don't.
the list. That was Lordship's first question was, I believe, do we have the list of the training? But the RAP is not in any way. There's a difficulty, my lord, because I'm now giving evidence. Those behind me can probably assist from finding the references from Mr. Vince's evidence. In fact, I could probably take you to it, but Mr. Vince's evidence sets out, his report sets out the types of restraint that were permitted, of which a RAP is, the best way I could describe this, my lords, is it's an earlier stage. It goes beyond a sort of light touch, hand on the elbow, guiding hand, but it's before you're getting into a more physical restraint. So you heard my learned friend talking about the supine restraint. So it's the RAP is stages before the supine, stage before the supine restraint.
Can you describe it in words? Or I'm
Yes,
not
my lord,
asking
it is-
you
it
to
is-
demonstrate on anyone sitting behind you,
Of
but
course.
just
My lord, it is a RAP.
as
It is as sounded.
that's what I
so
would
it is
expect.
putting
yeah.
your arms around somebody.
Yes.
And the respondent has to accept that if part of the gradation from that was you put your arms around somebody and then you put them face down, if there was training on that, then it would have been difficult for the court to say that that wasn't reasonable, because the factors, as I know we're hesitating before we come on to them, will include what training there is, and that training will include training on the gradation of the approach to the physical intervention. So where the respondent's case is where it's self-evident that there are steps, and it was certainly self-evident to the judge that there are steps in between that could have been undertaken, and they haven't been, then that is evidently unreasonable.
That is suggesting the judge concluded there were other steps.
My lord,
Didn't see that.
that's what she has recorded when the point was raised in the second decision. That
So all we have is 14 that addresses that point.
yes,
And don't forget, these are always dynamic situations. And you don't go through the logbook, because by the time you've got to the end of the logbook, the plane will have crashed. You need to look at the situation in real terms. So somebody has to decide quite quickly, is this working or do I have to try something else?
yes, and that of course is the point that the judge accepted when she looked at the other restraints. That those dynamic situations, and she specifically says that she accepts that there are decisions that need to be made, but they are decisions that are made within the bounds of what somebody is trained to do. Because those dynamic situations, unless they are an unforeseen event, that is what the gradation of the physical restraint is intended to meet.
Well, I'm not sure I, speaking for myself, I fully understand this unforeseen, unplanned
Yes,
plan.
of course.
Because I haven't seen any document saying these are the planned strategies.
Yes,
So you can't plan for everything. So you might say that any type of behaviour is foreseeable in some respects, but I don't quite understand the difference between planned, unplanned, foreseen, unforeseen. In other words, what has to happen is the carer has to respond to the situation in front of them and use their training and techniques to the best of their abilities to deal with it in a way that protects people from harm.
yes. I mean, on the first point, my lord, and forgive me, I cannot remember which of your lordships asked about whether or not the restraints were recorded in the integrated treatment plan, which was the care plan in which restraints should have been recorded. Now, it's not a subject of this appeal, as it were, but the point that was raised in the course of the evidence was that those restraints were not recorded in the ITP and should have been.
None were.
No.
Right.
So, but again, my lord, it's not a matter of the appeal. The judge does go on to look at this point when she looks at the use of the towel and the door method. But the ITP didn't record which physical restraint strategies were appropriate. The defendant's answer to this was, well, it's what's in the PRO Act, i.e. the techniques that are used. So
from the point of view of how it was approached at the time, there was this distinction was not drawn between planned and unplanned. Because the features that the judge refers to, paragraph, is it 130, were never applied.
Well, the respondent's position is they should have been, and there was an error in not actually having recorded the strategies in the ITP, and the appellant's own expert, Mr. Vince, confirmed that they should have been recorded and were not. So, but that didn't mean that the appellant's
Doesn't make them unlawful.
No, but it also doesn't mean that it was right for the appellants to say, well, there are no unplanned or planned. They were planned, it's just that they weren't recorded. And they were planned in accordance with the training that was in place. My lord, I might be able to give you some assistance in terms of what the standard that the school was operating under from the 2002 guidance, which my learned friend has referred you to. It's a supplemental bundle, and your lordship, I believe, has already referred my learned friend to some of the paragraphs of this. It's the 2002 statutory guidance on the use of physical restraint. It's at supplemental bundle, page 81.
Yes, I think I found this was issued by the Department of Health and the PFE jointly.
Yes.
Right.
That's right. And my lord, just pausing for a moment, my learned friend was critical of the respondent, or suggested that this was only referred to by the respondent. But it's right to say that Mr. Vince's report, which starts at page 2 of the Respondent Supplemental Bundle, referred to the guidance that was in place from 2019 in his assessment of what was reasonable. Just for your references, I know I'm taking you to 2 different bundles now, but he referred to guidance that was on the reducing the need for restraint and restrictive intervention.
I'm so sorry, I haven't got the page on.
I'm sorry, my lord, it's at page 17 of the Respondent Supplemental Bundle.
Thank you.
I'm just dealing with a preliminary point that the appellant has suggested that this guidance was, the 2002 guidance was produced by the respondent and somehow may not have been applicable, or that its application or shouldn't have been given sufficient weight. It was evidently given weight by the judge. And the point I'm making about Mr. Vince's report, the paragraph references to 7.9 at the bottom of page 17 of the Respondent's Supplemental Bundle, is that he specifically refers to the restraint guidance from 2019, and the respondent's position was, well, that's not the guidance that was in place at the time. So the experts seem to agree that the correct guidance to apply is the one that's in place at the time, and that was the 2002 guidance, which is the genesis of why you have the 2002 guidance. As your lordship indicated, having looked at paragraph 3.1, bottom of page 81, there are the different forms of physical intervention. And paragraph 3.3, which is at page 82, says it's helpful to distinguish between planned interventions, in which staff employ, where necessary, pre-assessed strategies and methods which are based upon a risk assessment and reporting care plans, and then emergency or unplanned use of force which occurs in response to unforeseen events. And paragraph 3.4 is really what we're looking at here, which is the scale and nature of any physical intervention, which must be proportionate to both the behaviour of the individual to be controlled and the nature of the harm they might cause. Paragraph 3.6, which is at page 83, the use of force to restrict movement or mobility or to break away from a dangerous or harmful physical contact will involve different levels of risk. There must be an assessment and minimising of risk to children, service users, staff and others, and pre-planning responses where possible. 3.7 is the elevated levels of risk, and that includes holding someone who's lying on the floor or forcing them onto the floor, any procedure which restricts breathing or impedes the airways, seclusion, where an adult or child is forced to spend time alone in a room against their will. Planned physical intervention strategies, which if you keep in mind the table, includes restrictive measures, should be agreed in advance by the multidisciplinary or school team, described in writing, and incorporated into other documentation. It's this bit that hadn't happened. And implemented under the supervision of an identified member of staff who has undertaken appropriate training, recorded in writing, and this is the top of page 84, so that the method of physical intervention, the circumstances when it was employed can be monitored and, if necessary, investigated. So it's not simply about monitoring, it's also about checking that the right methods that were used, that were trained on, and also not likely to cause any harm, were employed. And then 3.10 is unplanned or emergency intervention may be necessary when a service user behaves in an unexpected way. In such circumstances, members of staff retain their duty of care to the service user, and any response must be proportionate to the circumstances. Staff should use the minimum force necessary to prevent injury and maintain safety consistent with the appropriate training they've received. So even in a case of an unplanned or emergency intervention, the mechanisms or the strategies used should be ones on which they have been trained. And my lord, I'm going to come back to this in terms of the seclusion, unless it would assist to look at it now while we're looking at the document, to look at the false imprisonment issue.
Okay, are we going to move on from battery to?
There were just a few points, if I could just trouble you on the battery point,
Yep.
and just pick up then paragraph 115, because I know we've spent some time on 114,
Yes.
and I've probably tested your lordship's patience on 114. But what the respondent says is clear from what follows at 115, is that the judge expressly considered whether the use of force was reasonable. And we see that at paragraph 115. So any suggestion from the appellant, which is part of the claim, that the judge has missed out a part of the test is, in my submission, unfounded. But she then went on to consider the factors at 115 to 116 about whether or not, which went to whether or not the use of force is reasonable. And she does start up with looking at the appropriate content of the policy. She also looks at the appropriate training, which is in line with the evidence she'd heard from the experts, but of course it's also in line with the statutory guidance, which I've just taken you to. And she also considered another factor was the age and size of the child. Now in this case, she recorded that, and this is at paragraph 116, that the defendant was 10 years old at the time of the face-down restraints, and he was 4'6", and at the 50th centile for his age, he was 33 kilos. So he was a small and slight individual. And that factor, the reasonableness of the restraint in the circumstances, the size, was a factor that Mr. Vince, the appellant's own expert, had agreed was relevant. And we see that, for your lordship's reference, at the respondent's bundle. It's the transcript reference at 101. It's part way down, so it starts. The question starts at line 13, and he agrees from an answer he had just given around children coming in different sizes and shapes, and that's evident that you may have a child who at 10 years old could be 5'6" or 7, whereas the claimant in this case was a small and slight child. So the appellant's own expert agreed that one of the factors in assessing reasonableness was size. The appellant only suggested 2 other factors that were relevant to the reasonableness of the force that we used. And the first of those was that it was appropriate to consider whether or not there had been a dynamic response. And the reference to that again, while you're at the transcript of Mr. Vince's evidence, is at page 74 of the Respondent Supplemental Bundle. My apologies, my lords. It actually starts at page 72 of the Respondent Supplemental Bundle. It's the bottom of the page from line 20.
My understanding of this situation.
Yes. it is an unplanned intervention. And then Mr. Vince went on, as the lay witnesses did, to struggle to accept that what the record said, which is that they are face down restraints. And then when he was taken back to the statutory guidance, which, albeit in the later form, he had agreed was relevant to the determinations of reasonableness, he was taken back to the correct record and the idea that an unplanned intervention will occur where there's something unexpected about the behaviour. And Mr. Vince then, and this is page 74, Mr. Vince from line 17, was asked what was unexpected about the way that he was behaving. And Mr. Vince referred to the fact that he'd been setting off fire alarms, and that was not previously expected behaviour. It was not regular behaviour. And therefore that was such as to mean that an unplanned intervention was appropriate, i.e. one that, and I think the difficulty in any event is that unplanned interventions, at least insofar as they are looked at in the statutory guidance, are still interventions that are carried out with the training that's been used, with the training that's been implemented. So he says that this unplanned intervention must have been setting off of the fire alarm. And then it was put to, from page 77, it was put to him that in fact, in his own report, at page 285, this is from line 6, he had set off the fire alarm 3 months before, and it says that, this is page 15 of Respondent's Bundle, page 77, line 15, that the claimant set off the fire alarm and a touch support was initiated. And then it was put to Mr. Vince that this unexpected behaviour, which had made or rendered the face down restraints reasonable, was not in fact unexpected behaviour at all, because he'd behaved in that way 2 months previously, and then he agreed, bottom of page 77, line 5 onwards, that it would have been adequate time in which to prepare a planned physical intervention strategy. So the explanation that was given, or at least one of the factors that was given, and my learned friend now presses this again today, which is the context, was the behaviour, the way that the defendant was behaving. And at trial, what was said was the way he was behaving was unexpected because he'd been setting off a fire alarm. And that was evidently not the case.
What would the planned physical intervention strategy have been?
Well,
that you were suggesting would have been put in place?
Well, Mr. Vince had not, well, in the respondent's submission, it wouldn't be for the respondent to say what the strategy would have been in those circumstances. The point being that if it was a strategy, it should have been one that does not involve a face down restraint.
The strategy is controlling behaviour, and it would have gone back to, on your case, to PROACT. That was the strategy. Yes,
it would have been one of the strategies within PROACT. So the PROACT provides a form of training and a number of strategies,
yes.
And it would have been one of those strategies. So if he was setting off the fire alarm, strategies may have included, as it appeared to have done anyway, a touch support, but it may have included a range of different strategies if he acts in this way or responds in this way. The respondent's point is it comes back to what the physical intervention strategies are there for. And the behaviour, this is the point the judge picked up on, and then she refers to in her judgment. The incidences of dysregulated behaviour, where there may be some lashing out at a carer, were part and parcel of why physical intervention strategies are used in the first place. So for the defendant to suggest that a factor that you have to take into account is that he's behaving unexpectedly, and then not to be able to identify what is unexpected about it is in the respondent's submission was problematic.
Yes, but it still comes back to, I mean, you're talking about strategies, it still comes back to, doesn't it, the individual circumstances as to whether what happened was or wasn't reasonable. Because everything, all this is to do with controlling behaviour,
Yes.
addressing behaviour. And so I'm struggling with this, oh, well, there wasn't a strategy, there was planned, this was unplanned. I appreciate that was what the cross-examination was about and what the evidence was about. But I'm speaking for myself, I'm not sure it's very helpful when answering the question, was what happened reasonable or unreasonable in the context of physical intervention in terms of battery.
Yes.
You see, because
I do see.
it all comes back to, well, what happened was not part of the PROACT strategy.
My lord, it comes back to a number of factors that have been identified. One is it's not part of the strategy. The second is it's not something that the carer was trained on. I apologise, my lord, I'm now repeating myself. The third is that this is restraint of face down of a small child was a factor that was, when you're looking at reasonable force, was a factor the expert has said was relevant. And the judge concluded that he was evidently a small child, and that was a factor that went to the decision. And then there were two other factors that the defendant has suggested made it would have made it reasonable.
I understand that, but part of your case was there should have been a planned strategy. So what I'm seeking your help on, if there had been a planned strategy, what would it have said that
Yes.
would be relevant to the decision as to whether what happened here was or wasn't reasonable, in the sense of a reasonable use of force?
My lord, the planned strategy would have been in common with the other restraints which were found to be reasonable, which was that there would have been a gradation through the different restraints.
So does it come back to an assessment of whether or not, as my lord has asked, there were other strategies available? The only one has been identified specifically as the RAB, and they didn't work. Because if your planned strategies don't work, you have to do something else. You can't just do nothing.
Yes,
because
that's
you're
right.
dealing with a situation, so you have to do something else.
Yes, and what was done was and what was put in place was a strategy that there was no that could not be done safely, because it was a strategy in which there was no training.
And therefore, if that was the only available means of physically restraining him and stopping him setting off the fire alarm, it couldn't reasonably be used. They just had to let him go and set off the fire alarm. Is that the logic of your argument?
No, well, just in terms of the timing, my lord, that the setting off the fire alarm had occurred before. I don't want to go down a sort of too much of a following the defendant's line of argument, but it was simply a response to what the defendant had said around the unexpected behaviour. The point, yes.
One of the incidents, he was threatening to, maybe one of the town incidents, he was threatening to go off and set off the fire alarm. So take that as my example.
One of the town.
I've got those confused, but take that as my example of
Yes.
what he's threatening to do, something which is going to be highly disruptive and have serious consequences. And a RAP doesn't work. They have the policy they have. They don't have training on face down, but assume there is no alternative to stop him by way of physical restraint. You say unreasonable to use face down. They just have to let him go off and set off the fire alarm, do you, or not?
Well, no, because, my lord, that's not what had happened on other occasions. So on other occasions where one restraint is not, and bearing in mind the judge had all of these records and had gone through a lot of them, and in particular had looked at records where the 4 instances that were identified, which the claimant had said that disproportionate use of force was used. So she'd had ample opportunity to look at different records and identify the circumstances in which there is different strategies are employed without having to resort to inevitably dangerous, and as she records in her second judgment, humiliating.
I quite understand you say if there is an alternative strategy, that they have been trained in, they should use that, and we'll have to decide where the facts of the case lie and so on. But I'm just trying to test your argument that what matters is whether there was a planned strategy, and the particular emphasis you put, I understand why, on face down being something that the staff weren't trained in, and which the judge found carried additional risks. But that still leaves the question, if the circumstances are, we'll have to decide whether that is this case or not, but if the circumstances are that RAP doesn't work, and there's nothing short of face down which will physically restrain in order to prevent him setting off the fire alarm, you say the fact that that's not within the policy and there's no training means they absolutely must not use it. It's just unreasonable to do so, even if there's no alternative.
My lord, that if it is a case of one staff member, if there is no other alternative, well, I think it's going to be dependent on what the circumstances were, and if there's no other.
So you may say, if there's only one staff member and it's for that reason that it's the only available option, then they ought to have had two staff people available all the time to cope with emergencies or whatever that may be. But I don't think that alters the nature of the inquiry I'm making, which is if in the particular circumstances in which that particular care worker found themselves, she could only restrain him from setting off the fire alarm by moving from a RAP to face down, would it still be unreasonable?
My lord, in the respondent's submission, it is likely to be, because there's a balancing of the risks. And again, that is a risk assessment that needs to have been undertaken. And it said, well, it's a dynamic risk assessment, but in circumstances in which it is known, this is the point around the known behaviour, he's known to behave in a certain way, you're balancing a risk of causing harm to a child by restraining them with a technique that you are not trained in and which is inherently dangerous, versus the risk that they're going to set off the fire alarm. In my submission, that would not be reasonable, because that comes down to balancing the risks.
It does, but we know that Dr. Ribbon said that it's different in a hospital setting because they can monitor things afterwards.
Exactly, and that probably also comes back to the point that my lord made around the whether or not it would make a difference that this is new training was brought in, because there will be circumstances in which that's monitored. But I think answer the question, I'm sorry, my lord, it's taken me a while to answer it. Balancing the risks, the respondent would say that would not be reasonable. It would not be reasonable. It would not be reasonable bearing in mind the size of the child, because there are other factors which were agreed to be reasonable. Bearing in mind the size of the child, we're not dealing with an adult. We're not dealing with an adult who, when they go and set off the fire alarm, might cause other untold damage. We are dealing with a small child who has been restrained effectively in other ways and prevented from carrying out whatever activity he was about to carry out. Indeed, I just took your lordships to the reference to him being stopped through doing light touch support, which is effectively just touching his elbow.
Thank you.
Thank you.
I'm sorry, I've held you up for too long. We need to get on to
We
false
probably
imprisonment.
need to go on to false imprisonment,
Yes.
because that's very important too.
Yes. My lords, again, as I did with the battery, I don't know if you want me to take you through the authorities. The
You
respondent.
place a lot of emphasis on JLM and JOLA.
Yes.
Does it really help?
My lord, the respondent's position is it helps in terms of making clear what the elements are, because my learned friend has talked to you about the elements of the test, but then she referred to an intention to detain. And in my submission, that's not based on the authorities, and that doesn't indicate what the test is. You don't need to intend to imprison or intend to detain. What you need to intend to do, and this is from the Jallo case, is you need to intend to confine the individual or make them stay in a particular place.
So who's telling them that they've got to attend a particular class in a particular classroom and imprisonment? I'm not suggesting it's a false imprisonment, but do you say it's an imprisonment?
If they're being made to stay in that classroom,
No, they're being told they've got to turn up to that particular lesson.
well, they are still able to leave, unless some mechanism for locking the door, or in this case the towel around the door which prevents them from leaving, is in place. So yes, they will be voluntarily complying with it, and there will not be anything stopping them from leaving the classroom. If there is, that's of course a separate question, because
And if what's stopping them is not a physical barrier, but what he said, that if you leave class without permission, you'll have to have detention, some other punishment, does that make it an imprisonment?
no, that wouldn't make it an imprisonment.
Certainly
Because they
in the criminal law, if you take someone somewhere or tell someone to go somewhere and threaten them that they must stay there, otherwise there'll be consequences, that would be an imprisonment.
Yes,
Why is that not an imprisonment in the classroom?
I think that's an excellent point, Lord.
I'm sorry, I'm interrupting you and not letting you get going, but I'm myself troubled about where the barrier is between
Yes.
what amounts to imprisonment and what amounts to false imprisonment. I quite see in the cases I'm discussing, it wouldn't be false imprisonment. We're not in unlawful territory, but just in terms of imprisonment, are you saying actually it's a really very, very wide test?
I think the test that the respondent says it applies is, are they being made to stay in a particular place? And what the respondent says, the respondent's submission, is that having demonstrated that they are being made to stay in a particular place, it is then for the appellant, in this case for the school, to show that there is some lawful justification for it.
So this sorry, go on.
I'm sorry, my lord.
No, go on.
Yes. This then comes down to what justification is given by the appellant or the defendant for confining them in that particular place. So, in fact, I think in answer to the question, if you are being told you have to go to class, it probably doesn't even get there. But if it did, and you had to analyse it in that respect, you would say, well, the lawful justification is the upholding of the school behavioural policy. In that particular case, the respondent's submission is that, in fact, when you look at the way in which the case was put below, it's much more murky than that. It's much more unclear what the lawful justification was.
Can I just interrupt for a second? Because this was a school, but it had residential homes. So this was the home part of the whole premises.
Yes.
So how does your argument apply to foster carers, to parents who confine a child to a room? Is that imprisonment?
Well, my lord, I will answer that question, but that does take me back to a point that I was going to make about the appellant's submission, so I'll make it before I lose train of it, which is that this argument that the school was in loco parentis and that there is any analogy that can be drawn between the parents' ability to confine their children to a room was simply not one that was run at first instance.
I understand that, but I'm asking you a general question.
Yes.
Because you're saying imprisonment is made to stay in a particular place. I think, is that what you're saying imprisonment amounts to?
That
will happen daily in hundreds of homes, foster carers, other homes throughout the country. And it's quite difficult to see that all those amount to imprisonment.
Yes, they're being confined to a particular place from which they are prevented from leaving.
Yes.
And a foster carer can say, or a parent can say to a child, you go in your room and don't come out. Because this point didn't come up at first instance, my lord, it wasn't developed an argument, but I'm going to have to develop it now, and my learned friend also hasn't advanced any authority for the proposition. And the respondent would say this is part of the lawful justification, therefore the burden fell at this point on the defendant. If a parent confines their child to a room and prevents them from leaving, either by way of a lock or by wrapping a towel around the door and holding it closed or open. There's obviously different interpretations of it, but either way prevents them from leaving. Uses the door as a barrier, which was the argument that has been raised in this appeal, and that's what the appellant has said, it was used as a barrier. And that child is similar to the claimant in this case, a young person with challenging needs, then you would be looking at whether or not there would need to be a deprivation of liberty safeguards. So you'd be looking at whether or not there would need to be a community-based doles order, because that person's liberty would be being restricted. And that, again, this point didn't come up because it simply wasn't the lawful justification that was made.
No, but we're looking at it in terms of imprisonment, not looking at it in terms of deprivation of liberty, which is
Exactly.
considered low by the Supreme
Yes.
Court. And what? Because you were saying this case doesn't have broader ramifications. If any confinement of a child in a particular place is imprisonment, and the burden rests on those who have confined the child to that place to establish lawful purpose, I can see, and I have particularly in mind foster carers, often looking after troubled children. I can see this having very, very significant ramifications if you always have to go to lawful justification. I'm not saying you don't have to, but I just, looking at the broader ramifications of your submissions in terms of children who can be very troubled, the idea that any restriction to their room, putting it that way, amounts to imprisonment. It's quite a broad
Yes.
submission.
My lord, it only amounts to an imprisonment if it's not lawfully justified. The point is, the starting point is...
So you say it does depend on...
Has there been...
justification.
Absolutely, my lord. Has there been a
Otherwise it's-
confinement?
Yes.
Yes, exactly. So has there been a confinement? Has it been lawfully justified? And
Sorry to interrupt, doesn't Jolla indicate that you don't have to have a lock or a physical barrier?
Yes.
If the sanction is sort of intimidating enough, then it's just, you know, if you in Jallow it was a curfew. If you leave your home between 11 p.m. and 7 a.m., you will be liable to breach proceedings resulting in a fine or imprisonment. That was because the statute didn't permit a curfew, that was held to be false imprisonment,
Yes.
even though there was no lock. So
Yes.
now move to take my lord's example of foster carers, as I understand it, they're not in loco parentis. So you might say parents are in a special category, but foster carers aren't. And you know, Amelia, you will go to your bedroom now. No supper, that's it, go to bed. The idea that Amelia can then sue the foster carer for damages is very worrying to me.
If that was the implication, but that is not, in my submission, the implication. The implication is that a young person who is in a residential school can't be put into their room or can't be kept in their room, prevented from leaving without any lawful justification. And the reason it's relevant in a residential setting, and this comes back to my lord's point about the seclusion and the effect of the guidance, is that if there are strategies that are in place to manage behaviour, those are strategies which would need to be discussed and agreed with the actual parent.
Well, suppose the actual parents say no, don't agree.
Yes, which they did in this case.
Quite so.
Then it would be that then it would be for the school to say, well, there have to be other ways in which we can manage the behaviour.
Really?
Yes,
You
my lord.
can't even say this child is out of control. The child is going to have to spend 5 minutes, 10 minutes, whatever it is, in his room until he calms down. And your answer is no. The child must be given the run of the building, or the child can bring a damages claim.
If the child is prevented from leaving the room, and there is no basis on which that strategy has been discussed or planned, it may not have been agreed by the. But I think the point being that once it has been agreed, and if we're reaching a comparison with or drawing an analogy with parents, the parent is not doing it. So the decision from the parent is, my child will not be confined in the room.
Well, what do you base that submission, that it's, unless it's agreed with the parents, unless it's planned, so that it's unlawful? Where does that come from?
It comes from, or at least whether or not, sorry, my lord, it comes from we've taken it from the guidance.
So it is the guidance.
It is the guidance.
It's the guidance that makes it unlawful.
And the fact that if the comparison is being, or the analogy is being drawn with what a parent would do in this circumstance, the parent is saying, I do not permit that to happen. And that's the way in which the appellant is now running the case, having not run this at first instance, is that it is unlawful, it is that it was permissible, or it's lawful to confine children to their bedrooms and prevent them from leaving. If that is right, and if the ability of the school to do this is based on the fact that it's in loco parentis, again, my lords, I think there's a difficulty in the defendant now running an argument that was not run below to challenge the judge's decision when it comes to the lawful justification.
Is the consequence that if a difficult child is kicking off, to put it colloquially, it's perfectly lawful to put a wrap around him in order to keep him in the room, assuming that that's reasonably necessary to stop him kicking off. But it can't be lawful to hold the door shut. Both confine him to his room. One is part of the plan, and the other you say can't be unless it's agreed in advance. Why should they have a different yardstick?
I'm not saying that it could never be the case, but in the case of the defendant's approach, in the defendant's lawful justification, the defendant's position, it may be in another case this is true, but in this case we're looking at what the defendant did and how the defendant approached the use of the towel method. So the defendant's approach to the use of the towel method was inconsistent with its own expert's evidence. So an expert indicated that this was a seclusion, and secluding, keeping away a child from, keeping the child in their room and preventing them from leaving it, was not part of the planned strategies. So that there may.
I understand that, and that's the way you've been addressing it, and indeed the way the judge addressed it is that's what the guidance says, and therefore, as a matter of law, it can only be lawful if you have the steps set out in paragraph 3.8. But why should that be a definition of what is lawful, rather than what would strike me in the abstract, although I don't know if there's any authority for this, that the question simply ought to be whether the seclusion is reasonable in all the circumstances. And it may or it may not be with this prior planning, but I don't understand why the guidance should be the yardstick of whether in a particular case what happens is lawful or not, so as to give rise to a liability.
My lord, the guidance wasn't the only yardstick, wasn't the only thing that was being looked at, because the guidance was being looked at and applied by both Mr. Vince, who was the care and education management expert from the appellant side, but also considered by Dr. Rippon, who noted that in her view this seclusion would have been inappropriate at any length.
But forgive me, I'm just struggling with, the guidance is not itself law. It doesn't determine, or purport to determine what is lawful. So what is the test for trying to determine whether the seclusion or confinement is or isn't lawful for the purposes of false imprisonment? If it isn't, it's got to be other than reasonable in all the circumstances. What is the test in law?
Well, unless there's something that's some legislation that has not been followed, that's I can see that's difficult. There would have to have been and I accept that there had to be a point that it was a reasonable approach to take. Although the difficulty is that that's not the way in which it was put by the defendant. So the defendant has not said justification is based on our powers to do X, Y, and Z. So there would have to be some basis for the defendant saying we are empowered to keep a child in their room. Now, the defendant's own case seems to acknowledge that, because the way it was put by my friend, she said she'd referred you to the policy which permits children to be confined in their room in the cases of bad behaviour. I'm not sure she did actually take you to that part of the policy, but the defendant's own case said it'd be based on what the policy says. So if they are authorised under the policy to do it, then she would say, well, that's how we get through it, because there is an authorisation, there is something that permits us to do this.
Can I put forward a number of possibilities? One is, wouldn't the school be under an obligation to protect the child from harm? Wouldn't the school be under an obligation to protect other children from being caused harm by another child?
Yes.
Wouldn't the school be under an obligation to protect their staff from harm, the care workers? So there are a number of obligations, responsibilities imposed on, I know, as I say, we keep calling it's a residential, so it has both aspects to it, of protecting the children, other children. You might even say, although perhaps further down the line, property, staff from harm, gives them reason to implement policies that achieve that objective. And
Yes.
one of those might be confining a child to their room until they settle down. And I have in mind the evidence of, was it Mr. Long, who said that actually this is a much better way of helping a child settle down than direct physical intervention. So it's a beneficial strategy. It shouldn't be being sort of maligned as a hostile, I will not say, maligned as causing harm. It's actually, they said, my recollection is that Claimant sometimes found this method preferable to physical restraint. In cases of extreme aggression or emotional distress, this could be a safer and more effective way to de-escalate an incident. So does that not, does that not provide some lawful justification for taking this approach?
My lord, in the first part of your question, you talked about having a policy which provides it, so that the lawful basis for having a policy which provides something.
No, I was talking about general responsibilities, obligations. I mean, I'm sure there are cases in which children have sued parents for not taking proper care of them and protecting them from harm. There will be situations in which children have sued local authorities, not always successfully. So, I mean, there is, perhaps it's not relevant to look at local authorities in that sense. So I'm struggling with the idea that it's difficult to find lawful justification for taking steps that are said to be to protect the child from harm, protect others from harm, and in the child's best interests.
My lord, implicit, as I've indicated at the beginning of your question, was that there would need to be something that, where that has actually been set out, that there needs to be a policy. The school has to adopt a policy. I believe
Because we have a policy that we need to safeguard children in our care.
No, of course not, my lord. But the implication of that is that you then have a strategy, which is that they will then have a policy which permits them to do particular things. Now, the policy, there is nothing in the policy that permits them to confine children in their bedrooms in this way. And
So it comes back to the policy again.
it comes back to the policy, but it also comes back to the case that was put. And it was not suggested by the defendant that this was part of a balancing. And of course, the other part of the scale, as it were, is balancing not only safeguarding obligations to those three factors you identified, the claimant themselves, others, staff, and adding in a fourth, let's say, property, but also the balancing that with the claimant's right to liberty. Is the claimant's right not to be prevented from leaving a room. And so the question is, where was that balance struck? And where is the evidence of how that balance was struck? That would all be relevant as well to the lawful justification.
Can I ask you, does section 93 help us at all? The 2002 guidance treats seclusion as one form of physical intervention, in the same way as holding someone physically in a room might be. And section 93 applies to any use of force by people who are covered by the statute, and provides the test of reasonableness and the purposes for which it's the force may be imposed, very much along the lines of this kind of considerations my lord's been identified. So does section 93 apply a reasonableness test to lawfulness in this context?
In my submission, it doesn't, because it's specifically looking at the use of physical. I accept that it's a physical intervention, the door, and just that is all, of course, also what the judge found, that it is a physical intervention, but it's the use of force.
It's not the use of force.
It's not a use of force, because
the deprivation of liberty or the restriction of liberty is not imposed by the use of force, you say.
Well, there's no suggestion that if he come out, it's imposed by the use of a barrier, which is the door, which prevents him from leaving. I'm not sure we could say that that was a use of force. Section 93.
Is it your case that force has to involve some physical force applied to the person?
That's the purpose of section 93, because the purpose of section 93 is to provide effectively a defence for circumstances in which there is a laying on of hands, there is a physical touching, and that's not what is happening here. However, it doesn't mean it's not a restrictive intervention. It evidently is, because he's being kept in his room, and we see that from the guidance.
Physical. I think the guidance treats it as a physical intervention.
It's a physical intervention, but it's not a use of force.
Physical in what sense?
Well, because it is imposing a barrier between the claimant and the staff member. This is certainly Appellant's case, and it's defined as a seclusion. So it is not a the opposite of a physical intervention might be a talking intervention. It's not an intervention by speaking to somebody. It's an intervention that involves something physical about it, and in this case, moving the child from keeping the child in one place, so they are physically contained.
So your case actually, as I understand it, is there can be no lawful justification because there's no ground on which that can be established.
Well, the case that the respondent says that it needs to answer is whether or not any lawful justification was raised at the time of first instance.
Well, you look at the defence, they said that that they did what they did to protect the staff, other children, or the claimant himself. That's what the defence said, both in respect of the allegations of battery and in respect of false imprisonment. But you say there's no legal basis on which they can rest that contention.
Yes, we say that that completely fails to completely fails to take into account the fact that the claimant has a right to liberty, and he may be a child, he may have been a very troubled child, but he's still entitled to move around. And that justification, when it came to looking at the false imprisonment, does not in any way balance that right. It doesn't refer to it. And in part, that's because the way it was defended was that the door was open and he wasn't prevented from leaving. So the actual defence was run on the basis that he wasn't prevented from leaving. But in my submission, there's a fundamental inconsistency there, because the way it's argued by the appellant is that it can't be unlawful to require a child to remain in their room, but he wasn't required to remain in his room.
Well, you can't, but you say it can't be lawful to require to remain in his room. Can we look at page 169 of the court bundle, which has got the pleading about the town. So the claimant was not deprived of his liberty. And I'm interested in some paragraph 2. The use of a towel to hold the claimant's bedroom door ajar was done to protect the defendant's staff and the claimant from injury. It was not done to deprive the claimant of his liberty. It prevented injury and allowed the claimant to communicate with and see the staff. I think you say, well, that's as maybe, but it's not a defence. And that in the case of restriction of liberty, reasonableness is not a defence.
The reason it's not a defence is because it misses out, because it fails to grapple with what was in fact happening. And the reason that the judge was right to find that there was no lawful justification was because there had been no consideration and no balancing of the risks associated with it. And in particular, there had been no reference back to the claimant's parent, the person who has responsibility for him. And that the same point may equally have been true of the batteries, but it wasn't put in this way. That if you look at page 2.1, subparagraph 2.1 at 169, what the defendant, the lawful justification, such as it is that he was separated from peers for short periods of time in accordance with the school policy. But he wasn't, because there's nothing in the school policy that says that the use of the towel method and confining someone to their room is permitted. He was not isolated or detained. Well, the appellant's own expert view was that what was happening was a seclusion, which is an isolation and is keeping him away and preventing him from leaving his room. And as to the remainder of it, the use of the towel to hold the bedroom's door ajar was not done to deprive the claimant of his liberty. Well, the intention, so the only reference there to the claimant's liberty is by reference to an intention, but the claimant does not need to show that there was an intention to deprive him of his liberty, merely that there was an intention to confine him to the room. So that's the only way, that's the only reference in any of the documents to the claimant's liberty. And I take the point that actually the reference back to parents may not necessarily be determinative, but it is part of the assessment of whether or not a strategy is appropriate to be used. And in this case, that assessment was not undertaken, which means that the imposition of the strategy was not done with any rounded look at the impact on the claimant. And yes, after the event, Mr. Long has identified in his evidence that, although he didn't point to any particular instances, that it may have been of a benefit to him. The strategy itself, and it's unfortunate because one of the pages is the other administrative point I was going to come on to your lordships with. One of the pages is missing from the bundle about the record from the 12th of June 2009, which indicates the impact on the claimant of the strategy. I have it to hand up to your lordships. When I indicated at the outset there were two
Is
administrative
this
issues.
page 97?
My lord, no. It's it's a page that goes behind the incident of the 12th of June 2009, and it would go behind page 109 of the supplemental bundle. So page 109 of the supplemental bundle is incident of the 12th of June 2009. And if you look down at the bottom, it says, after the
He
student
refused to come out of.
And then it goes on to an incident on the later that day.
Right.
So I have printed those up. I'm afraid it's I've given a copy to my learned friend. It's rather difficult to read. Thank you. The point I'm making, my lords, is that if you are looking at what was done by the defendant and the processes that were adopted in deciding whether or not there was a lawful justification for confining him to his room, it's not sufficient just to simply say we are doing it to protect, and it's not sufficient to simply say and the door wasn't open, he could communicate. It wasn't closed. On the first point, we knock those out. The respondent knocks those out quite simply in saying that the fact that the door wasn't completely shut or that it wasn't locked is not relevant to the confinement question. The fact that he was able to communicate with staff members, also not relevant to the confinement question. Which leaves you with this generic point that has been made without balancing the question of his right to liberty versus the necessity of the strategy. And there is no consideration of it. And as I said, part of that consideration, part of that balancing exercise, as the judge noted, would include considering the strategy in concert with those who are responsible for caring for him, where it is indeed a strategy. And this is where the judge found at paragraph 130 of the liability judgment, page 98, there's nothing in the policy which describes the use of the town method and the circumstances in which it's appropriate to be used. Now, I know this is coming back to the policy point, but let's take a wider point. There is nothing anywhere which says the circumstances in which it's appropriate to use this. Now, if my lords are looking at through the cases, the lens of whether or not it's reasonable, that is evidently a factor. When do you use this towel method? At what point? There was evidence that the local authority disapproved of the strategy. So the local authority had said they weren't happy with the use of the strategy. The local authority is the one that has placed the claimant there under section 20. And the real difficulty with the evidence from Ms. Day and Mr. Vince was that the towel method was a physical intervention. Mm. So, and just answering my lord's point, I know I said I'd come on to that. I think the judge is saying here that it was a physical intervention.
Yep.
My lord.
Yep.
And it was also planned. So that, and there was a requirement when you're assessing whether or not it's reasonable to do this. I will put it through this framework. When you're assessing whether or not there's reasonable to do it, if you need to assert that wording, there was a requirement for the intervention to be agreed in advance by a multidisciplinary school team, working in consultation with FXS and his parents, described in writing and incorporated into other documentation, and implemented under the supervision of an identified member of staff who'd undertaken appropriate training. Well, there's no indication of what training the staff had. There's no indication of circumstances in which, as I said, the circumstances in which the TAL method could be used. There's no documentary evidence suggested or discussed with FXX's parents. And my learned friend made a sort of sweeping statement to say, well, it was discussed with him. That wasn't the case, my lords, and you can see that from paragraph 127 of the judge's decision, that the claimant's father found out in September 2009, sometime after the process had been put in place, that the claimant was being kept in his room, and said that it has the same practical effect as locking it with a key. And then Miss Day had no recollection of the meeting on the 14th of September. This is paragraph 129 of the decision. And then it appeared that despite having said that the method would not be used, it was then used again twice subsequently. And it's at paragraph 129 that the respondent refers to what this method actually was. It was a confinement, it was a seclusion. I'm taking you back to this, my lords, because the respondent's case is that it has established that there is a confinement, and it's quite clear from the evidence of Mr. Vince. This is a seclusion, therefore it's a confinement.
Yeah.
It was then the case. It was then for the school to say what the basis for it was. But the difficulty was that although it was set out in defence that it was some protective measure, as I've said, that doesn't balance the right to liberty. And actually the way it was put at trial was confused. And we see that from paragraph 127 of the judgment. There is a confinement, but what's the reason for it? And Miss Day suggested the TAL method was an unplanned or emergency intervention. As the judge rightly identified, a natural reading of the statement was that it was a strategy developed in direct response to increase in physical restraints. It wasn't an unplanned or emergency intervention. So the justification that was actually made at trial was that, well, we just had to do this in an emergency. But that is not the basis which was disclosed from her evidence. The basis disclosed from her evidence was actually it was a strategy that was in place and had been in place for at least 7 months. My learned friend gave some information to your lordships about the development of the strategy in her submissions today, referring to an incident with a carer. None of that was before the judge, although I'm not sure really that how the method came about is relevant to your determinations you need to make, my lords. But it was an instance, again, of my learned friend referring to evidence that wasn't before the court and that no one had had an opportunity to look at. I think shortly put, my lords, the question for your lordships when you're looking at whether or not this decision there was an error by the judge in the decision is whether or not the elements of the talk were made out to start with by the respondent, and in my submission they were, because it was quite clear that he was being confined. And secondly, whether or not at trial there was any lawful justification. And that's not the way, as I said, that the case was put, because there was an evident confusion by the defendant as to what exactly they were doing here. It wasn't the case that it was said we've balanced these various factors and we've concluded that it is the best way to keep him safe. That might have been the way it was set out in the defence, but it's not the way it was put at trial, it's not the way it was put by the witnesses. So the judge is then left with a justification which is confused, a justification which fails to accept it's quite clear what the TAL method is, fails to accept it despite the evidence of the defendant's own expert, and says, well, it wasn't a planned physical intervention, even though it evidently had been in place for some time. And in fact, my lords, as you may have noted from the bundle, was in place sometime before the suggestion that there was some escalation in his behaviour as a result of the claimant's father taking parental responsibility, because it was first used.
Sorry.
Oh, I'm sorry, my lord.
Would it be fair to say that the the ratio of the judge's decision on course imprisonment is paragraph 130?
130, my lord.
130.
Yes, well, it's combined, and the rationale for it is earlier. Yes, my lord.
It's confinement, so confinement, seclusion, imprisonment, and it's a planned intervention. It's not in the policy, ergo it's unlawful.
It's yes, and it's the step earlier, my lord, is at paragraph 129, which is that the TAL method, so it's confinement because it's a form of seclusion, and that's agreed by Mr. Vince, who agrees that it was an internal, that then resiled from his position by assessment of internal seclusion. Yes, it was a supervised containment, isolation of a child, young person away from others in a room area in which they're prevented from leaving. And then the decision in terms of paragraph 130 looks not only to the fact that there's nothing in the policy about it, there's nothing to describe the circumstances in which it's used, but also when assessing the reasonableness of it, if that's, when assessing whether or not it should have been used, because she is following on from Mr. Vince having stated in his report that the TAL method was a reasonable method. She is going on to consider the fact that it's not in the policy. There are no circumstances in which appropriate to be used are not set out. The local authorities disapproved of the strategy. There hasn't been any consultation on it. It's not been described to the parents. And in any event, what had not been said, and therefore couldn't be reflected in the judgment, is that it had not been said that this was the only way to manage his behaviour. So the judge can't address a negative, but it's right to say that the defendant had never said this was the only way to manage his behaviour, was by confining him in his room.
And therefore it's unlawful.
Yes. Because the burden, as I've indicated, was on the defendant to justify it. And there was no justification given.
If you look at paragraph 126, the judge there refers to Miss Day's evidence. Speaking for myself, that looks like an attempt at justification.
Yes, what she said again, and the difficulty with this is that it's.
Well, I'm dealing with. You were saying there was no justification put forward. It was put forward in the evidence. I'm just questioning whether this is evidence of in support of justification or reasoning. That's rather than justification.
To the extent that it is, it wasn't. As the judge has identified, it's not properly fleshed out because there's no time frame indicated. Her argument is that he became a lot bigger and stronger, but no time frame is provided, and he appeared to like physical contact, and so other methods were tried, including using a door in between the claimant to calm down. So yes, it is a form of a justification, but it's not one that, as I've indicated, balances anything about the claimant's right to liberty. There's no justification there. The claimant's right to liberty is no consideration of whether or not it is something that would be approved of by those who do actually have parental responsibility for him. And that's a relevant factor, and it goes to the reasonableness. because effectively the school are imposing a strategy to manage the needs of a child who needs would otherwise be managed at home, and therefore the decision would be taken by a parent as to how to manage their needs. It's managing the needs of a child away from the home without any recourse to or indication as to how they are doing it in circumstances in which there is a proposal to confine them.
And it makes no difference whether it's 5 hours or 5 minutes.
Not according to
It
the law.
goes to quantum, but even 5 minutes is unlawful, if you're right.
Yes, that's right. If it's right that there isn't a lawful justification, and so the judge has not ignored what has been said, but she has gone on to say that there are the other factors that are relevant were simply not in play. And it is in the context as well, I would say, of a concern that the approach that has been taken by the school is a confused one as to what exactly is happening. It's not made clear that this is a strategy. It's said that it's a strategy, and Ms. Day says it's a strategy in her witness statement, but then tries to resolve from it and say it's not a strategy in the face of a concern that it will be said to be a seclusion. So there is a real lack of clarity from the school as to what in fact is happening on the ground.
I'll see if my lords have any further questions on this important issue, because we need to have a few minutes on damages.
Yes, certainly.
There's something I'd like to ask,
Please do.
but I think I wonder whether what's happened here is that the school has been anxious to distance itself from what's said in the 2002 policy applying and requiring the steps that paragraph 3.8 identifies. And it sought to do so in two ways. Stay, both of which are identified at 127. With Ms. Day saying it was unplanned, and the judge rejected that, and Mr. Vince saying it wasn't seclusion, and the judge rejected that. And the judge then going on to effectively adopt the 2002 policy as the yardstick, and therefore 130 saying it wasn't lawful because none of those steps were undertaken, although it would have been had they been complied with. But that begs the question as to whether the judge was right to treat the 2002 guidance as the touchstone as to what is or isn't lawful. And it may be because of the way it was argued, but she doesn't seem to have addressed the question, which may be the relevant question, which is whether the conduct was reasonable in the light of all the circumstances, irrespective of the terms of the 2002 guidance. If that's the right test as to what the lawful excuse, or whatever the phrase is, for false imprisonment. Although I should just articulate that because it's going through my mind to give you an opportunity to say what you want to about it. Everything you've said so far I entirely understand about the way the case has been argued and so on, but if as a matter of law the right question is was what happened reasonable in the circumstances, I'm not sure that the judge has either sought to apply or applied that.
Yes, My lord, if the right question is what is reasonable in all the circumstances, the factors that the judge has identified go to that point, because the judge is looking at and informed in this sense by the evidence that was given by Mr. Hinds. But when you look at, and I indicated before, when you're looking at whether or not standards have been upheld, you look at what the policy says. So she starts from what are they and what do they say they are authorised to do, and that, in my submission, was when she's looking at the factors that are reasonable. In a way, she's looking at the same factors and considering many of the similar factors that are relevant.
Not considering the sort of factors that we've been discussing that are referred to in the evidence about the best interest of the child, the best interest of the other children.
Well,
in the particular circumstances of each incident.
Because what she is looking at is
she's looking at a process-driven inquiry rather than an incident-driven inquiry, if I put in that.
Yes, and that is of course the way it was put, because it was not suggested by the defendant, and that there would need to be an inquiry into each of the individual acts of
I understand
imprisonment.
that, and that's a very fair point for you to make, but we're being asked to give a judgment which may have ramifications in other areas of the law, and in which we need to address what the right approach is, even if it wasn't that which was contended for the school.
Yes, even if, even if the judge had looked at each individual instance, which she does in any event in the second judgment, she goes on to look at each individual instance. The factors that would still be relevant to a determination of whether or not it was reasonable would still have included all of those factors that she outlines at 130, and she would need to have been.
And did it actually require the father to be asked? And to your knowledge, he would have said no.
Well, I think that's it. I don't think it's right in the short knowledge he said no, because he.
But, I mean, I suppose wouldn't have known what the answer was. Is it right that they simply couldn't reasonably do it because they hadn't asked?
I think if the suggestion is, which it now is, from the appellant, that the basis for them acting in this way is because they are acting as a parent would act. They're acting loco parentis. If a parent is saying this is unacceptable, then that is evidently a reasonable consideration, because the parent is saying, I do not agree with my child being confined in this way. And if the alternative is the child can't be kept at that school where that strategy is employed, and has not said how many it was employed in respect of any other children, my learned friend gave some information about that today, but that was not before the judge, then alternative steps would have to be taken, and the alternative process would have to be put in place. Whether or not a parent agrees to the restriction of their child's liberty or to some confinement must evidently be a circumstance that is whether or not it's reasonable to employ the strategy, and therefore continuing with the strategy without having consulted a parent. And once the parent has been consulted, they say don't use it, and the local authority says don't use it, to continue in it again, notwithstanding that.
And the same would apply to a foster carer.
Yes.
They'd have to ask the parents if they wanted to do this.
Well, I think if they are confining a child, I think that then brings back to the separate question of which I raised earlier, which had it been before the court is a point that may have been ventilated, which is whether or not parents are under any circumstances permitted to say prevented from leaving their room.
I think your point is, however justifiable it might be, it's not for this school justifiable without getting the consent of the parents, because the only justification for doing it is exercising the same power as a parent would be allowed to apply.
Yes, and also...
And I think it therefore follows that the same would apply to a foster parent. They'd have to actually seek the parental approval before they could do it, even if it was circumstances in which the parent could treat treated as reasonable.
Well, if it was not the, and if not the parent, then the local authority. If the local authority had also said, having placed this child with you, you are not to prevent that child from leaving their room. And it is difficult in this circumstance because we're not actually imagining the exact scenario of the door in fact operating as a barrier. We're pulling in a potential situation in which the child is told to stay in their room and is not, and complies with it because they're concerned that they won't get any dinner, which is not what is happening here.
So there could be any number. It could be locking the front door. It could be locking the door so the child can't leave at
Exactly,
night. That would be a confinement. So it does have broad ramifications.
And the question then is what is the basis on which it was said it was lawful to act? And I think that comes back to the point, and risk of repeating myself, that basis was not made clear. It doesn't mean that in other cases it will not be made clear. And in particular, the bit that is missing is any balancing exercise. The bit that is missing is any risk assessment. And that is the point that is alluded to, or not alluded to, that's the point that's made at paragraph 130. What's missing is looking at this in the round and looking at this intervention in the round.
All right. A few words on damages.
Yes, my lord, I just want, before I move on, I just wanted to very briefly touch on the document that I'd handed up to you. It is, as I said, the second part of the incident record at incident record number 80 from the 12th of June, and it would simply goes to a point that my learned friend made, and I believe was addressed in her submissions. And in response to one of your
So far as I'm
questions.
concerned, it's illegible. If you'd like
Yes.
to, it's so faintly copied. If there's something in it on which you want to rely, could you read it out slowly?
Yes, of course. Yes, it says partway down that the claimant began crashing about in his room and pulling on the door. I mean, it's just a small point, my lord, but it's reflected in the second decision, on the quantum decision, that the suggestion that was made at that point that the respondent would have to be demonstrating that he was trying to leave to render the confinement false imprisonment, and was unable to do so, is not correct. It's at paragraph 29 of the second decision, page 111. And there's a reference there to the record for the 12th of June 2009. And the judge saying it could have been related to his behavioural issues, but it could equally have been related to response to being confined to his room. And I think another point that it's made there at paragraph 29 by reference to the records is that on the 8th of June 2009 there's no reference to violent behaviour whilst the towel method was being utilised. The point being that in the records that had been produced, and the way in which it was put before the judge, there was no analysis by the defendant in each case. This is something that needed to be done to safeguard, or what the rationale was on each individual case. And that was a burden for the defendant to discharge, not in the instance of the false imprisonment claim for the claimant to discharge. It was for the defendant to say, in each case, this is why it was justified. I'd simply say that in a way turns my learned friend's submissions around, because my learned friend has suggested in this appeal, but not below, that it was somehow incorrect for the judge not to have looked at every single instance. Well, that burden fell on the defendant to say, in each individual instance, what is a confinement was justified. And the defendant didn't discharge that burden. And so it was only subsequently when the question of quantum arose, and therefore the amount of time that the confinement took place, that the number of minutes of each detention were set out in second judgment. But the overarching point being, and building on my earlier submission, that it's not sufficient for the defendant to simply say, well, there's a global reason for doing this. In each and every instance, if the appellant is right that the judge needed to have looked at each and every instance, then equally the appellant needed to have justified each and every instance by reference to the behaviour that was occurring at the time.
15 years after the event.
Well, by reference to the records, and the defendant simply didn't do that. Criticism is made of the claimant for not cross-examining Mr. Long, but Mr. Long did not give any evidence about individual instances where he'd been involved. His witness statement is a generic statement. So he had not provided in his witness statement, and indeed none of the witnesses have provided in his witness statement any justification for the individual instances. So the judge is left with a proposition which is unfilled in. To the extent that your lordships therefore are concerned that there is some wider proposition at play, I would simply repeat what I said earlier, which is that in this specific case, there was no lawful justification. It doesn't mean that in others there won't be, where there will have been consideration of, as I said, the balance of the right to liberty versus the protection of others, indeed the protection of the claimant. But that is not what this judge was faced with. And so any wider principle can't attach in my submission to this decision. The judge was faced with the justification that she was given. My Lords, might I just turn very briefly before I...
Of course you may.
My Lords, I'm again, because this point didn't come to fruition, wasn't raised, certainly in respect of foster carers, and I realise that this has come out of the discussion. But if foster carers were going to implement a measure like this, the expectation would be that it would be set out. It would be clearly set out, and there would be discussion of what would need to happen, and it would be in the care plan, so that there could be an agreement about whether or not this was appropriate. So in fact, it is an analogous situation. It may not be that the foster carer would ever be able to go back to the parent, but if the parent is not somebody who's available, then the local authority would give a decision. And if that's sort of any assurance to your lordships on how this can work in practice, I think that's the most I can do based on that example. But in a way, it's analogous with what is happening here, which is that there needs to be a proper consideration of whether or not this is a strategy that should be employed, bearing in mind that it would certainly risks constituting a deprivation of a child or young person's liberty, and that more is required than simply saying, well, it's for protection. On the aggravated damages then, my lords, the respondent's position is a simple one, and I note to start with that my learned friend says she doesn't disagree with the amount, the amount of the aggravated damages, in which case the case has moved on somewhat, because originally it was said that there is some proposition that it was only appropriate to award aggravated damages of 10 to 15%. I understand that my learned friend is not pursuing that argument.
I think she's abandoned it, but she's not advanced any positive argument.
Well, to the extent that she hasn't abandoned it, the submissions in the skeleton argument are to the effect that there is no indication of any mathematical or arithmetical formula that you apply. And indeed, if you are going to look at the maths of it, the indication from the Thompson and Sue case, which you will find starts at page 113 of the authorities bundle, is that an appropriate sum, and this is point 10 of the guidance that's given. I don't know if your lordships want me
You've
to
dealt
take you
with
to it.
skeleton.
It's dealt with in the skeleton argument, but as the simpler maths point, my lords, is that the determination there was that if there was going to be an award of aggravated damage, it should be at least £1,000, and today's, or taking it at the rate that would have been appropriate as at the 10th of November 2024, which is the date of the decision. At the time the judge made her award, that would have represented a sum of at least £2,500. So even if you are looking at the maths of it, it's quite clear that the aggravated damages is not out with what would be an appropriate sum in this case. Turning then to
In the case of the false imprisonment, what the judge's reason for making the aggravated damages is that the towel method was used on 2 further occasions, 5 minutes each, in the days between 8th of September and 17th of September. So that's £1,500 per incident.
My lord, it wasn't just that second reason. Of course, there were 2 reasons that were advanced, your lordship, in terms of the rationale for the aggravated damage on false imprisonment. We see those at paragraph 33 of the second judgment, which is page 12. I'm sure you're there, my lords. The first reason was that the school had failed to take any advice on the method, and my learned friend says, well, there's lots of internal advice, and she points to a statement from Dr. Karen Onions, but none of that internal advice referred to the use of the towel method. Now, the reason this is important and the reason it went to aggravating the damages is because the judge had heard evidence which indicated, and we see that from paragraph 127 of the liability judgment, that that the school were unclear really about what it was that they were doing, and they were unclear about the lawfulness of it, and they couldn't advance to her any basis on which it is said that it's lawful, and therefore they were persisting in something without having identified whether or not it was lawful, and that is a form of aggravation. And the second, as you've identified, my lord, is that despite the request both from the claimant's father and the local authority to desist, and my learned friend couches this in different terms, she says that it was the local authority passed on a request. I mean, my lord, that's simply not, that's not what the evidence indicated. The local authority was not happy with the method being used. And you've seen the email from the claimant's father, who was strongly concerned about the method being used and asked for it to stop, notwithstanding that it carried on. And it carried on, and the basis for that, or the explanation given for that, was that people might have been on holiday, which is problematic, obviously, because if something has been identified as something that should stop, to continue in it, or not to take steps to ensure that all relevant staff are aware of the need to discontinue it, is a form of conduct or species of conduct which, in the respondent submission, amply meets the threshold for aggravated damages. Although, my lords, I would say that the way in which it's put by my learned friend suggests that those requirements of malicious, high-handed, or oppressive must be met, whereas in fact in the Thompson Sue case they are identified as those factors may include. So it's a non-exhaustive list, and the judge has identified that the reason for the aggravation is because there was a continuation of a policy without having actually identified whether or not it was something that was lawful. And as I've said, my lords, my learned friend's suggestion that the internal workings were sufficient to provide advice or to inform the school that this was an appropriate strategy was not sufficient, evidently, because the references my learned friend makes to the evidence and the evidence of other individuals simply doesn't refer to the Tal method, where it came from, who devised it, who thought it was lawful, who'd done the balancing exercises. And in terms of the aggravated damages relating to battery,
Yes.
those are dealt with at paragraph 17 of the second decision, at page 107 of the core bundle. And the judge indicates that there are two features worthy of disapproval. And the first is that at the time there was a failure to appreciate the significance of using a face-down restraint. And the basis for this is in the judge's findings that Miss Day did not record the outcome of her conversations, and she did not indicate, or there's no reference to what further training or discussions there were. And the relevance of that, simply touching on it, is that Mr. Vince had given evidence that if there was a departure from the policy, or there were training requirements that came out of the result of that, they should be recorded, and they were not. So there was a failure to appreciate. And I take the Lordship's point earlier in questioning that, well, Miss Day just didn't think it was a problem, so why is that problematic? And at the risk of coming back to the policy, it's because the policy says you're not supposed to. So if there was going to be a rounded consideration of the reasonableness and proportionality, the expectation would be that there would be some consideration of it and some record of it, and there simply wasn't. Not simply was there no record in the papers, but there was nothing in Miss Day's witness statement. And that leads on to the second point, which is that in the course of the litigation there was a failure to appreciate the significance of the face-down restraints. And my lord, I don't know if my learned friend had identified the transcript references for you, but we can see that there is a reluctance. This feeds into her decision, or the way it was put in the first judgment, that there was a reluctance to acknowledge that they were face-down restraints. So even though both Mr. Long and Miss Day were taken to the record, and it was pointed out to them that they were face-down restraints, neither of them would agree to it. The reference for your lordships is at the bottom of page 238 of the supplemental bundle, starting from line H, and that's the transcript reference from Miss Day's evidence. Mr. Long's evidence is at page 148 of the supplemental bundle.
So what was the first one? Page 2.
Sorry, my lord. It's at page 238
Thank you.
of the supplemental bundle.
That's Miss Day, yeah.
And Miss Day, yes, and she answers the question when it was put to her that
Don't worry, I just wanted the reference. Mr. Long?
238 onto 239. I'm sorry, my lord, just to make sure you've got the complete reference. It's 238 over to 239. And Mr. Long is 148, the supplemental bundle, starting at line B. And he says there, notwithstanding my learned friend urging upon you that these were expert professional witnesses whose accounts should have been accepted, Mr. Long started his evidence by saying he can't comment specifically about what happened because he wasn't there. And then, of course, went on to struggle to accept that the policy said face down, which, if you are assessing my learned friend's submission, that the judge was somehow in error in not taking into account what these witnesses said. Well, they weren't there, they acknowledged they weren't there, and it's difficult to see how they could have assisted her because they wouldn't accept that on the face of it, the record says face down. So that goes in my submission both to the point about the factors that are relevant, because my learned friend says a relevant factor is that these professional witnesses understand what is happening, but also it goes to the aggravation. And the other point that went to the aggravation was that the appellant had expressly relied on a witness report and evidence from Mr. Vince, who doesn't make any reference to the face down restraints, notwithstanding those being in the pleaded case. So the school's approach had been to rely on the evidence of a witness who was avoiding what was one of the parts of the claim that was front and centre. And that is, yes, of course, as the judge acknowledges, the defendant, the appellant, can't dictate what is in the report. But if their own expert refuses to engage with a key aspect of the claim, and then also struggles to acknowledge the face down restraints in the course of cross-examination, that is an example, the respondent would say, of the sort of conduct in litigation which is worthy of disapproval. And it's not simply a difference of opinion. He just simply does not refer to it. And in my submission, for quite obvious reasons, because it was the part of the claim that was clearly of concern. He refers not only to the face, not only does he not refer to the fact that there were any face down restraints, but he also doesn't refer to restrictions being in breach of the policy. Sorry, restraints being in breach of the policy. My Lord, in final comment, this applies both to the aggravated damages as it does to the assessment of the judgment as a whole on the liability point. The judge had before her the records. My learned friend's case on behalf of the school was never that those records were not a suitable starting point to assess either the battery or the false imprisonment claim. She read those records as they are, and you will see in particular how she dealt with that in the second judgment, dealt with the question of whether or not there were any, the sequence of events to the restraint. In my submission, she undertook a fair reading of those records. She couldn't be assisted by the other witnesses who weren't there, and in any event were struggling to actually accept the wording of the records, so they were not going to be much assistance to her. And she was assisted by the evidence that she heard from the expert witnesses around what might be reasonable factors to take into account, and she took all those into account in making her decision on the batteries. And for false imprisonment equally, she looked at what it said on the face of the records that she was taken to. She identified that there was a confinement, and she identified that there was no lawful justification that was raised, and I've indicated the reasons for that. But above all, this was a determination for the judge to make, having gone through the records and having heard that evidence over the course of 9 days, and heard evidence testing all of these different points and examining them. It certainly is the case in terms of the aggravated damages that is preeminently for the judge to decide, having heard the way in which the case was put and having heard the way in which the witnesses approached matters, and having looked in detail at documents which you have not been provided with, Your Lordship, around the, for example, on the false imprisonment, the dates on which the strategy was implemented, the fact that it wasn't notified to the claimant's father. So these are preeminently judgments for the judge to take, and in my submission she reached a well-rounded and considered decision, on which the respondent notes that she reached clear decisions, and I would ask Lordships to go back to it in terms of the restraints that she found were not proportionate. And she didn't just say it's because they're in line with the policy. She thought carefully about the fact that there was an assessment to be made in the circumstances of each restraint, and that assessment was not to be impugned in respect of the judgment of the 4 restraints that she found were lawful. Unless I can assist further, Lordships. Thank
Very
you.
much. Ms. Foster.
Lord, I'm sorry to rise, and I know it's late,
Right.
but it shouldn't take me more than 5 or so minutes if I could just please address
Right,
several appropriate
we'll rely on you.
without going back on.
Yes, as ever, no need to repeat what you said this morning.
Not going to. The first point, just to remind your lordships that the basis of the respondent's tenure at the school was under Section 20 of the Children Act. That was because, and that applies when the person with parental responsibility isn't in a position to accommodate the child. I apologise, I don't have the section to hand. I've just looked at it quickly on my instructing solicitors.
Right, my lord on my right knows it by heart. So
I'm
that's
very
good.
much obliged. As far as I'm aware, that requires the local authority, who of course placed the respondent at the school, to take cognizance of the child's wishes insofar as that is reasonable. I'm not aware that there's any requirement for the parent to be able to determine how the child is managed. So I make that point just to respond to all of the discussion that's been had this afternoon about parental involvement. The next point, you've been told quite categorically that there was no evidence about Miss Pusey. There is. Carol Day's witness statement, paragraph 17, page 62 in the electronic bundle. There are also numerous transcript references, and I will provide you with a list as requested. In relation to the towel incident, you've also been informed incorrectly that there was no evidence about that. Well, there is in fact some fairly robust detailed evidence in Carol Day's witness statement, paragraphs 26 to 36, and again numerous transcript references that I will provide you with. On a further point of evidence, you've been informed, again erroneously, that the defendant's witnesses at the trial didn't accept that there had been face-down restraints. That's actually not how their evidence was presented. What they didn't accept was that Miss Pusey had embarked upon her attempted restraint of the respondent by going to a face-down method. Their evidence was that she clearly attempted to put her training into practice. That hadn't worked. She'd become overwhelmed and had ended up on the relevant occasions with the respondent in a face-down position. My lords, next point in relation to information as to the gradation and the options that might have been available. As I highlighted at the outset, the PRO Act is a methodology that relies on de-escalation as a primary step, and one then moves to other steps in order if that is not successful. There is evidence, there was evidence before the court. Will Long's witness statement, paragraphs 8 to 10, explain broadly the options available, and the statement of Dr. Roberts that you don't in fact have, because my learned friend didn't want that to be included in the bundle and I wasn't going to cause a fuss, but Dr. Roberts was the person at the school responsible for the PRO Act training, and he provided a statement that dealt with that. It wasn't challenged at first instance, and so the judge did have evidence, should she have wanted to deploy it on that topic. The Lord's next point, criticism is made that the integrated treatment plan did not record the incidents of restraint. The integrated treatment plan is a live document. to which the various multidisciplinary practitioners contribute in various sections. The restraints are, as you are aware, recorded as they happen contemporaneously in the daily logs, which are numerous. There simply wouldn't be the space to put all of those reports into the integrated treatment plan. So that's a misconception and perhaps a red herring. The other criticism that there was no indication, no written account as to what system of restraint was to be used is also misconceived, because the school used the PRO Act system, and so any local authority placing a child would have regular contact with the school. There would be discussion about every aspect of the child's tenure, and nobody could have been in any doubt as to the methodology employed. Next point, and this is perhaps an important point to put into context. You've been referred to the evidence of Mr. Vince only for selective parts. He being the appellant's expert on residential care. It was not the case that Chrissy Pusey restrained the respondent to stop him setting off a fire alarm. She restrained him because he was attacking her, and that is absolutely clear from the documentation. It is correct that on one and possibly two occasions earlier he had set off the fire alarm, but he was not restrained to stop him setting off the fire alarm. He was restrained because he was trying to hit Chrissy Pusey. The interaction between my learned friend and Mr. Vince at trial, in my submission, doesn't assist. That wasn't a proximate cause or of any relevance to the circumstances in which she applied the manoeuvres that she did. And the notes at the end do explain the rationale for the restraint being applied, and in all of these three cases, the rationale is to protect the respondent and herself from harm, not to stop him setting off a fire alarm. So that in my submission does need to be put into perspective. Similarly, the reference to Mr. Vince using the word seclusion, well, at certain points in cross-examination he did, but his evidence was quite clear that the scenario, insofar as the three, I call them batteries, are concerned, was as presented by the witnesses, that the carer, Miss Pusey, started out by trying to apply the training, became overwhelmed, and then did what she needed to do to protect herself and to protect the respondent. And in relation to the seclusion point, which I've just gone off track, which is now relied upon to justify the friend's submissions in relation to that issue, that just doesn't have any context, because Mr. Vince did not accept that the Tower method was inappropriate. He explained to the judge that he actually used it in his own practice, and that it was a legitimate method to be used in appropriate circumstances to put a buffer between a child and a carer where otherwise harm might ensue. So just to put Mr. Vince's evidence into perspective, next and finally, in relation to how the case was put below, my learned friends either implied or expressed criticism in relation to that. The claim as a whole, the hearing as a whole, was very much focused on the issues of negligence. Insofar as the add-on, the bolt-on alternative claims for battery and false imprisonment were concerned, the defendant appellant put its case exactly as I have put it today. It contended that the threshold for those torts being committed could not possibly be met, because what carers were doing in all of these situations was entirely reasonable, considering the situations that they had been put in, and that what they were doing was for the good of protecting the respondent and protecting themselves in those situations. And so it is not correct to say that the case is somehow now put on a different basis, because it is not. Of course, it may have been submitted to the learned judge that actually he wasn't trying to leave the room, but that was in the context of he wasn't trying to leave the room, because what he was actually trying to do was to attack the carer, not leave the room. But it comes back to context, and the defendant's case was clearly put on the basis that none of these interventions could be criticised, because they were all entirely reasonable in their own context. And there was a wealth of evidence that the judge had to draw on, because over the 9-day period, most, if not all, of these incidents were looked at through the lens of the various witnesses and the experts. So again, rather express suggestion that the defendant should have ensured that the judge actually analysed all of the incidents. It, in my submission, not justified. Well, look, they are my, I hope, short.
This morning we discussed your providing transcript references. If you would like to provide a list, please do that tomorrow.
I will, yes.
Don't argue the case, just do headings. And apart from that, there's nothing further that we ask from either of you. We'll reserve judgment, and counsel know what I'm going to say next, but I still have to say it. We will send out a draft in the usual way. A draft not in the sense that we want the case re-argued, it's simply for correction of any typos, obvious factual errors like dates and so forth. We then hand down the judgment in the modern digital way by publishing it on the National Archive and so forth, until formal publication. The contents of the judgment are confidential to the parties and their legal advisors. Thank you very much for your helpful oral and written arguments. You've been very patient with us both.